has allowed this mentioning last week, but the requisitions were not sent because the file lies in courtroom number 1 and that was not written in the mentioning statement. That is the only reason.
Daily permit to mention your lordships. This matter will have to assign by Honorable Justice Lord to give for 2025 lordship by your lordships and Honorable Justice we have received to the and take up this matter. Initially, this order was passed by his lordship. It is Honorable Justice standard and Honorable Justice. The assignment was done to 190. This is the order.
CPN.
CPN continuity. Main reading has already been disposed of by his lordship. The Honorable Justice standard and Honorable Justice.
All right, we'll see. Get the file. We'll see when it is to be listed. Let us get.
Item number 1.
Yes.
Yes, my lord. Paper book is voluminous, my lord, 6 volumes, my lord. But the facts and the issues are very short, my lord. But, my lord, I precise, my lord, state the facts, my lord, which leading to prefer this appeal, my lord. The facts is this, my lord, that in 1990, my lord, a career advancement scheme was introduced by the government of West Bengal Finance Department. Under that particular scheme, my lord, that the government employees who are in the scale of pay of scale number 1 to 13 and who had completed 10 years of service, he will be extended a benefit to the next higher post and higher grade pay. And petitioner joined in the cadre of the West Bengal Statistical Service junior cadre in 12th on 12th January 1981, my lord. And petitioner's service was confirmed, my lord, on 1st June 2086, my lord.
86.
86, my lord. And by operations of the ROPA rules, my lords, ultimate this was given effect to from 1/1/1986, my lord. So petitioners completed 10 years service, my lords, in 1996, my lord, and on the basis of the order dated 2nd December 1996, petitioners was allowed to move to the next higher scale, my lord. Then in 2001, my lord, a modified career advancement scheme came into, my lord. Under that particular scheme, my lord, that the employee who are in the scale of pay from scale number 1 to 16 and who had completed 16 years of service should be allowed to move to the next higher scale of pay and higher grade. Petitioners completed.
This scheme came in 2000.
Yes, came into 2001, my lord, 13th March 2001, my lord. And the petitioner, my lord, the completed 16 years of service, my lord, and my lord, the petitioners was extended the benefit of the next higher scale of pay, my lord. Then thereafter, my lord, on 12th December, my lord, 2012, my lord, another scheme, my lord, was launched by the government by way of notifications that the government employees who are in the scale number 18, my lord, and who had held that post for 3 years, my lord, he will be extended a benefit of the next higher grade, my lord. So petitioners, my lord, since the petitioners, my lord, held the skill number 18, my lord, on and from 2001, my lord, and the petitioners completed 3 year service in that particular grade, my lord. So petitioners is entitled to the benefit under that particular notification dated 12 December 2012, my lord. But the petitioner and the petitioners retired, my lord, on 31st July 2013, my lord. But the petitioners was not extended the benefit. Petitioner made several representations, my lord, that the representations was not, my lord, acceded to, my lord. And ultimately, after the 9 years, my lord, in 2021, my lord, they came out that there was a excess payment made to the petitioners. So unless that will be paid, my lord, so that will be paid by the petitioners, the benefit should not be extended, my lord. That is their stand, my lord. Against that, my lord, that the tribunal, my lord, that the applications was filed, my lord, that
What
the
is the date?
tribunal held.
What is the date of the order containing this stand?
Yes, my lord. That is, my lord, at page, my lord. 668.
That is the impugned order before the tribunal.
That's it, to order. Yes, at page 662, my lord. The operative part, my lord.
Can you give us the date?
Yes, my lord. 6 December 2024. At page 667. Operative part. my lord.
The document starts at which page?
Yes, my lord. It starts from 662.
No, 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 no. Where is the order you challenge before the tribunal?
Yes.
Where is the order you challenge before the tribunal?
Oh, that order before the tribunal. Yes. What? That is, my lord. Right. That tribunal against the law. Okay. Well, this applications was moved before the tribunal against non-actions and inactions on the part of the authorities, Lord, for not granting the benefit, my lord, under the notifications 12/12/2013.
But you told us that they took a decision that unless you return some money, they will not do it.
Yes, Lord, that is, my lord.
So that you must have assailed before the tribunal.
No, that is what happened, my lord.
You
What
did
happened?
not.
No, my lord.
You then let us see what is their decision, please.
Yes, my lord. At page 669. In reference to the order passed by the Honorable West Bengal Administrative Tribunal, way number 454 of 2023, this is to inform you that your prayer regarding awarding of 25 years cash MS benefit has been considered based on the observations of Finance Department communications by Q number so and so dated 14 November 2021. In the process, your career advancement scheme and modified career advancement scheme benefit awarded to you prior to your retirement has been reviewed, and consequently an amount of rupees 2,41,913 913 has been calculated as overdrawn amount, and the same requires to be refunded through tier 7 challan in the linked treasury and or pay on accounts dated bank under head accounts number so and so, and all relevant documents regarding refund of the same may kindly be submitted to this office at the earliest. It is pertinent to mention that you have already consented to return the overdrawn amount by your email dated 9 December 2023. It is also pertinent to mention that after the refunded process is completed, the file will be sent to the administrative department for awarding 25 years cash or otherwise eligible in compliance of the orders referred above. This actions, my lord, is absolutely contrary to the rules, because the rule says, my lord, that the no recovery could be made, my lord, after expiry of 4 years from the service, my lord. So this was done, my lord, in 2021, my lord, and he retired in 13 July 2013. I invite your lordship's attention to the relevant provisions of the rule.
So what is there in the tribunal's order by which you are offended?
Tribunal though came to a findings that petitioners is entitled to the benefit.
Where is that finding? Read
Yes, my lord.
let us read that finding.
At page 662,
Yes.
tribunal's order, my lord. And operative part, my lord, at page 667. Having heard the submissions of the learned counsels representing both the sides, and after examinations of the records in this case, the tribunal finds that by a memo dated 3rd December 2021, the department had communicated to the director in charge that such prayer for MCS in favor of the applicant Amit Gupta, ex-deputy director, has received the observations of the finance department and suitable actions has been asked from his end. The above memo is cited under. I am directed by the order on the subject mentioned above and to send herewith copy enclosed the observations of finance department the so and so dated 4th November 2021 for taking necessary actions at your end. From this important document, it is evident that this matter was referred to the finance department and its opinion was obtained. However, the respondent authorities, in particular, the Bureau of Applied Economics and Statistics, were sitting tight over it and have not taken any suitable action. Since the Bureau has not taken any decision or nor communicated the same to the applicant, the tribunal is of the strong impression that the prayer for modified career advancement scheme of the applicant has already been settled. Mr. Mondol Learned Counsel has also not been briefed by the respondent's office about the outcome of such opinion expressed by the finance department in their communication to the department. Milord, this was done, Milord, in 2024. He retired in 2013, Milord.
There is no finding that it was allowed. You said that there is a finding that it has been.
Yes, Milord. Yes,
There is
Milord.
no finding.
So that is why, Milord, my respectful
So
submission.
there is
Milord,
no finding that it was allowed.
no, Milord. When?
And the tribunal has directed them to take a decision. So what is wrong with that?
Yes, Milord. That decisions they have taken, that has been challenged, Milord.
So now that decision will be challenged directly in the High Court.
No, Milord, what happened, Milord? What happened, Milord? Because under what circumstances we did it, Milord? We explain these positions, Milord. Milord, this matter was filed, Milord, long back, Milord, 8 years before, Milord. Then the matter was not heard, Milord.
OA
Then
is of
expedient-
23.
No, yes, Milord. Then
OA is of 23.
the previous, prior to that, Milord. Prior to that, another application.
You
was
have
filed.
what can be done?
Yes, Milord.
You have not been
No,
diligent.
no, because I will satisfy
You
your Lord.
retired in 2013.
Yes, Milord.
There is no urgency on your part. You have taken all the time in the world to approach the tribunal. It's not that you have been pursuing the matter. You retired about 12, 13 years back.
No, Milord. What happened, Milord? We retired on 13th, Milord.
Yes.
Then similar, Milord, the similarly situated persons was extended benefit on 15th.
Maybe. That's
Then,
not,
Milord,
we
when
are
I
not
came
on
to
merits.
the-
We are on why directly the writ court. That is only what we are asking you. Why directly the writ court should look into.
No, Milord, that is.
You
that-
go and
that-
assail it.
Yes, Milord, that I will explain before your Lordship, Milord. Because why, Milord? Milord, the court directed.
It may be an illegal order.
Yes, Milord.
You may say it is illegal.
Yes,
So only legal orders are challenged before the tribunal. It's not that a legal order will be challenged.
Milord, for rendering substantive justice.
What
Milord.
substantive
But the-
justice? That is what the tribunal is there for.
Yes, Milord. Milord, what happened, Milord? Because tribunal sat tight about the matter for milords more than 2 years, milord. And milord that the
Tribunal sat tight over the matter
yes, milord.
for
Then
2 years.
I will show you.
The
milord,
tribunal has passed the final
no,
order.
milord, the contempt, because on the basis of the rule of contempt was issued against the tribunal.
Whatever it is,
Yes,
it
milord.
has
Then,
finally been
milord, then,
decided.
milord, within
So
1 day,
therefore,
order
for
was
all
passed.
times to come, the matter has to be entertained by the High Court.
No, milord, because
We are asking you, why should we look into it?
because this was brought to the notice before the milord, Arstwell division bench, milord, that this happened, milord. They again relegated the matter to the department, milord. Then again, milord, that the fourth round of litigations will be started. Because why?
Has to.
Because we
It
caused
has to.
No, milord.
There is no way out. That is
No,
the
milord.
procedure.
No, milord, we caused to issue a rule of contempt that was the resultant product, milord. So that's why they started.
After the tribunal's order, which was passed on 6/12/24,
Yes, milord.
they have come out with the impugned order.
Yes.
Challenge it. Who is stopping you?
No, milord, otherwise, milord, again, milord, it will.
It has to. What is the way out?
No, milord,
You
because
cannot avoid. Either you do it there or you do it here. You have to do it.
milord, this is a continuation because the same stand they took, milord. And
They
that
did
was-
not.
Yes,
They
milord.
did not.
Yes, milord, that was canvassed before the tribunal.
They did not.
Yes,
sir.
milord, if I read out
Did see the tribunal has not affirmed any stand taken by them. The tribunal has directed them to consider.
milord, this, they, milord, submitted before the tribunal that there was an opinion. But they won't be able to disclose that. It
An
was
o-
the laches
an
on the part
opinion-
of the state.
Maybe who is saying no? That's not the point.
So
The
that-
point is why here. That is the only point.
So the court had the occasions, milords, to delve into the
Sorry.
issues, milord.
No, sir.
But the tribunal,
We cannot.
delegated
We
the
cannot.
matter because
We cannot
we
open.
was to have, milord, issue a contempt, milord, against the tribunal. That's the resultant product.
You may.
And
You
the
may.
person's, milord, he has retired in 2013, milord.
Yes, he has. He has come very late to the forum.
No, milord.
Yes.
Milord.
Yes, very late. He
Milord,
has taken no steps.
milord, 2019. I
Correct.
invite your
6
lordship
years after he
on to
retired.
one document, milord. I invite your lordship.
Sir,
that-
he has
that-
come to the tribunal 6 years after he retired. So we have seen his urgency.
No, milord, it was under process. I invite your lordship.
So let it be under process forever.
Milord, page 274. Once, milord. Milord, for a moment, milord. At page 274.
274.
Otherwise, it will be a travesty of justice.
Oh, it
milord.
may look to you like that.
Milord,
It may
again,
look to
milord,
you like that.
say
You are
again-
entitled to your opinion.
Yes, milord, that the tribe.
You are entitled to your opinion.
Litigations, milord.
Yes.
Because, well, this was issues before the tribe.
Which
Yes, milord,
page
at
you are
page
trying to?
274.
Yes.
Milord, on 22nd October 2019, the Finance Secretary wrote a letter, milord, that
74.
274A, capital A. Subject: awarding MS benefit after completion of 25 years of service to Sri Amit Gupta, the petitioner. The undersigned is directed to refer to the above and to request him to submit the following documents in conclusion with awarding MCS benefit of 25 years.
Yes, we have seen it. It's a very
That is,
small letter.
all these documents have been submitted.
Very
The
good.
petitions was
Good for you.
accepted. All we had the issues before the tribunal, milord. Even, milord, that today what they have come out with this order in 25, that was, milord, argued, milord, by the learned council,
May have
milord,
been.
before the tribunal.
May have
But they won't be able to produce any order, milord. So therefore, milord, that the court passed an order, court should have decided the matter, milord. But instead of, milord, decided the matter, milord, relegated the matter, milord, to the department once again, milord. So against that, milord, we prefer these applications, milord, because all issues before the tribunal, including these issues, milord. So that my respectful submission, that this is a writ court, milord, is under Article 226, is a court of equity, milord. Your lordship, milord, for rendering justice, milord, your lordship, milord, take into all these considerations, milord. These are all, milord, all, milord. Otherwise, milord, if it is, milord, then again, milord, rolled out, milord, for another 5-6 years, milord, he may not see the color of the order, milord. He may die, milord. His conditions is not good, milord. So under these circumstances, I am not praying, milord, unjust, milord, before your lordship, milord. Because all were issues before the tribunal. And law simply barred. They cannot do it. This is a statutory bar. If, firstly, my lord, that I will show you, my lord, erstwhile tribunal held that this recovery is unjustified, cannot be made. Against that division bench, my lord, the state appealed before the division bench. Division bench came to a findings that recovery is not justified, my lord, and set aside, my lord, their applications, my lord. So on two ways, my lord, this order cannot stand, my lord. It is, my lord, teeth on the, my lord, rule 9 of the rules, my lord, death cum retirement rules. It clearly says, my lord, it casts a prohibitions after expiry of 4 years from the date of retirement. No recovery could be made on any account, my lord. It's a clear statutory mandate, my lord. And they are saying that I agreed because it is no stopple shall lie, my lord, on the statutory operations, my lord. It's a well-settled law. I have brought the judgment, my lord. This is the position. I restrict submit.
That is something which has to be decided at the appropriate forum.
Yes, my lord, that but my respect.
That is what we are saying. We are not saying it is correct. We are not saying it is wrong. We don't know.
No, it is my respectful submission that all the time has gone, my lord. It's not my fault, my lord. I have shown to you, my lord, that in 1919 this was under process.
Yes.
So, my lord, so my respectful submissions is this, my lord. This could be decided. It's a simple issues, my lord. Nothing remain in the matter. Because law didn't permit. Law is very clear. I'm showing you the, my lord. I have already handed over, my lord, the rules, my lord. Your lordships, my lord, have a look, my lord, upon
We
the.
are on maintainability, then only we'll go to the merits. Why directly High Court?
No, my lord,
Cannot
this
be,
is-
sir.
my lord,
We will not enable. We may do it in an appropriate case where there is some dire urgency, something is going to happen because of any reason. Our hands are not tied. There is no absolute bar, but not in every case because there is some delay.
my lord,
And when you have approached the tribunal 6 years
No,
after retirement
no, my lord, here,
for such a person,
no, my lord, here in this.
we don't intend to.
No, my lord, why, my lord? Because this was issues before the tribunal. This was discussed. This was argued. But since, my lord, that they could not produce the order, my lord, so therefore, my lord, court could not form any opinion. But court came to a finding there is a strong case, my lord, in favor of the petitioners, my lord.
Court says it was settled, but it doesn't say
Settlement.
settled which way. It does not say whether settled against you or settled for you.
So that is why, my lord, I am just pointing out, my lord.
And it says we are of the opinion it must be settled.
No,
It does
no.
not give a finding that it is settled.
This is not
It
disputed.
is a
that-
presumption of the tribunal.
What the 25 years is concerned, my lord, that is not disputed. That is settled.
We are not going to exercise.
They have said, my lord, that excess amount was paid, so therefore, unless
We
that
don't
is
know. You may be right. We are not saying you are wrong.
that is rules, my lord.
So that is what has to be considered.
My lord, that I respectfully submit before your lordship. Your lordship can do this, my lord. Because this is a court of equity, my lord. My lord, the substantive justice, my lord, cannot be, my lord, otherwise obstructed on the questions of technicalities,
Alright.
my lord. It's a mere technicalities. Issues before the court. Court has the occasions, my lord, to go through all these circumstances, my lord. Because this order was discussed, but they could not produce, my lord, before the tribunal. And for that reason, my lords, that the petitioners cannot be made to suffer, my lord.
We don't
And
know.
in two ways, the order is absolutely patently illegal, my lord. On two ways, my lord. First, my lord, it is a statutory bar. You cannot make any recover. And secondly, the same issues were decided by the tribunal and high court. Here that this recovery is unjustified. I'll take you, my lord, to your lordship, my lord, to the findings of the tribunal. Only two parts, my lord. Yes, my lord. Just, my lord. At page, my lord, 203. My lord, at page.
Yes.
It appears from the note of the finance department that the case of the officers who have either retired or resigned or died before October 19, 2005 after getting the benefit of promotion to the upgraded post may be treated as fait accompli and need not be reopened at this stage. On scrutiny of records, we find that on date of observations of the finance department, out of 60 officers, those appointments were regularized by the cabinet in 2015. At least 47 officers have either retired, died, or resigned from the service. In the two original applicants, there are only 7 applicants, it will be unfair if the 7 applications are not allowed the benefit, while such benefit have been allowed to the majority of the similarly placed officers whose service were regularized on the basis of cabinet decisions in 2005. Accordingly, the benefits extended to the applicants may not be withdrawn and any amount of salary may not be recovered as excess payment with the conditions that the pay and allowances already allowed to the applicant may be considered as personal to them. So recovery is, Milord, that was also set aside by the tribunal, Milord, and that was upheld by the division bench of this honorable court, Milord.
At that point of time, you were sitting on the fence. At that point of time, you were sitting on the fence. Though you had retired in 13, you were sitting on the fence.
Your losses, Milord, a KI Sefar's case, Milord, that the persons who are not being litigated, Milord, he cannot be deprived of the benefit.
Very
by
good,
critically
very good,
situated
very
persons,
very
Milord,
good.
who are extending this benefit.
So therefore, we have seen what you are trying to show.
Yes.
Until then, you had not awakened to your rights. Though you had retired 6 years prior to filing of that OA.
Yes, Milord, because
You waited for the outcome of that litigation.
suppose,
And
Milord,
today you want us to take it up directly under Article 226.
no,
That is the only issue we are trying to understand.
no, because
We are not on merits. You may be right. We don't know. We don't want to go to that
Milord,
stage.
it is absolutely contrary to law, Milord. This is apparent,
Maybe,
Milord.
maybe not.
It doesn't require, Milord, even to go through any other factual aspect.
Maybe,
It's a
maybe
pure
not.
question of law, Milord.
In every case,
This is of the observation.
in every case, there is not a case without a question of law. What is the unique about your case?
So, Milord,
What is so
here,
unique?
Milord, your lordship, because I respectfully submit before your lordship, Milord, appreciate the situation and circumstances of the petitioners, Milord. Milord, because not that was not the issues, Milord, is a foreign, Milord. So therefore, now we straightway come up before this tribunal. I I I respectfully submit because it's a writ court, Milord.
Which case that order was at
660.
662.
Yes.
That is the tribunal.
660.
From
Grateful.
Item number 2.
We said anything on it.
আজকে প্রেজেন্ট করে না তখন অ্যাক্টিভিটি আপনি ফেল করে প্রচুর ক্রিয়েট করে না that I've been allowed to vote for the channel that
Affidavit of service. You are
Yes.
filing.
all are appearing. No, this relates to the question of the appointment of principal in the government college.
Government college.
Here, Lani Tribunal will not dismiss my prayer on the ground since you have participated, you cannot challenge. Well, this is not the law. Now that participation would prevent me challenging if I will take the issues which are known before the participation. Here, my challenge is that the recruitment rules and allotment of marks was not
So
done.
just before that, we proceed. Though somebody has been recruited already,
Yes,
so they are also before us.
we have served them notice. We have served them notice, but till date they have not appeared. That's my
So today's service is regarding them only.
সার্ভিস affidavit সার্ভিস দিয়েছো সবাইকে দিয়েছো এটা কোথায়
How many private respondents?
One,
are-
one.
No, 9, 10,
No, no,
11,
selected
12, 9, 10, 11, 12, 13, 14.
they participate. So the selection
9 to 14.
প্রত্যেককে দিয়েছো
So there are 5.
they are all participants, but the selection was of one gentleman. That is respondent number.
But you have made them parties.
They have made party. I don't know why. But anyway, সবাইকে পার্টি কেন করেছে এই না? Because the selected candidate is item 12, respondent number 12.
No, but since they are respondent,
No, I follow. I follow.
where is the service? When did you file the affidavit of service? Today.
Where is service school? অত সবাইকে পার্টি করা দরকার ছিল না শুধু সিলেক্টেড ক্যান্ডিডেটকে তুমি করলে কেন? হ্যাঁ, কিছু লোকের পার্টি করে বসে আছে এনিওয়ে যখন করেছে
So there, out of these 14, which are for the private respondents? In the affidavit, please help us.
respondent number 12 is the person who was selected and he has been appointed. Others are all below the contestant candidates in the same selection process.
No, perhaps there are the state respondents have also been served by post.
State has appeared.
They have appeared. So out of this affidavit of service, which are the 5 pages relating to the private respondents we are asking?
Let me just check it out. Oh, okay, আছে। Private respondent কোনগুলো? এইগুলো। ঠিক করে। ঠিক করে।
লোকে লিখতে হয় মুখে মুখে পেলেও
Give him. He will take it.
পোস্ট করলো না
He may put a mark on this.
Carefully করে
No, 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 no. Pencil দিয়ে করে, pencil দিয়ে, pencil দিয়ে।
এই তো এই জন্য তপন দাকে দরকার পেন্সিল আছে দেখে দাও চেয়ারম্যান দরকার নেই কিছু দরকার নেই সেক্রেটারি চেয়ারম্যান সেক্রেটারি চেয়ারম্যান সেক্রেটারি করে দিয়েছে এই এই আর কিছু
পেয়েছে কিনা? Deliver হয়েছে কিনা?
ঠিক তো আপ টু 9 তো এক্সপার্ট কেউ পার্টি করেছো তুমি কিছু 9 দিয়েছো 9 10 কোথায় এক দুই
Could be done in a better way, you know. It could be done in a better way if you paste it with the name of the person on a particular page. Otherwise, we have to keep looking at. He is respond number 12.
yes
So it has been served on all the respondents. Affidavit of service. That's not the correct one.
page? 2778 is the Badshah code.
Yes,
Exactly put
that is at page 13. Perhaps.
2781 is confined number. Yeah.
He has marked 18, but I think it is 13.
13, 13.
আরে কোনটা দেখো না তো। Them dispatched. See, তুমি নিজেই তো জানো না কোনটি। আমায় দাও, আমায় দাও।
Just see where he has pasted the receipts. You will get it on the left side, the third one.
Yes.
That is in the name of Badshah Ghosh. It reads 781 IN at the last. 781 IN appears to be at page 13. If the paging of my affidavit and your affidavit is the same,
78. Yes, 7781
IN. It's 778 IN. Now 778 IN is perhaps at page 13. He has
That's
marked
page 13.
he has marked 18. 18 is not the
No,
correct.
no, 13. এটাও তো 7781 এটাও তাই।
2778, yes,
778278 আছে।
including
এটা কত
respondent.
নম্বর ছিল?
But there is none to
হুম। দেখেছি, দেখেছি।
So we can proceed.
Yes, now the kindly sees the order passed by learned tribunal. The dismissal on that ground, my lord, is a misconception of law because my challenge is that the selection procedure as prescribed by statute was not properly followed. Now the learned tribunal dismisses my application saying, kindly come to my lord the third page of the order. Therefore, the tribunal is clear in his opinion that this application is unsuccessful. Candidate questioning the very process in which he fully participated has turned around and complains against the commission. This prayer is not a valid prayer and does not deserve to be interfered with. My complaint was not relating to the affairs which was known to me before participating in the interview. Had that been the position, the tribunal was correct. My complaint is that as per the recruitment rules and advertisement, the allotment of marks was not done appropriately. That has to be looked into, but crossing the record of the tribunal, nothing else. The advertisement is at page 66.
And the respondent has already joined.
Yes, yes. There is no scope for any interim order, only scope for the scrutiny by the Honorable Court. If Court finds something, then otherwise it's not. To be very fair with the Honorable Court and the person who has been appointed.
Yes, where is the advertisement? You want to show the
Page 66. But the most important and notable, the ability to read. But at the top of the advertisement, that applications are in prescribed format, then notably, ability to read, write, and speak in Bengali is an essential qualification for recruitment to the post and service mentioned below. Provided that the said compulsory requirement of knowledge in Bengali, including the ability to read, write, and speak in Bengali for recruitment to the following post shall not be applicable to those candidates whose mother tongue is Nepali. This will be tested at the time of interview. But this particular gentleman without candidature is earlier cancelled because he because he had little bit of inability to read and write Bengali. 83. And then another part not is
He has earlier been found not conversant.
Yes.
Where is that?
that is paragraph 41. Sorry, page 41. I have categorically given the reference that one of the recommended candidate, namely Badshah Ghosh, has no knowledge about read and writing, excuse me, the English, which is very much essential criteria for selection post of principal government college. Not only that, the selection was previously 2007 rejected under the same cause of action, cause not action, by the PSC. And at this time also, my lord, my instruction is that there was no test undertaken by the PSC on this aspect also.
Yes.
Then kindly comes to, my lord, the category of academic qualification experience at page 66. Item E, a minimum score stipulated in the academic performance indicator API based performance-based appraisal system with emphasis on published work designated in accordance with the UGC Regulation 2016, described under the Appendix here 2, but has to be gone into. Now, my lord, will find, so what the API score is concerned, that is at page kindly turn to, my lord, page 73. The API score of the applicant before, my lord, item 5, Amit Banerjee, was 964. And whereas of Mr. Badshah Ghosh is 569.5. That though he comes within the category of eligible, but not the high API score on the part of Amit Banerjee requires not the appropriate proportional distribution of marks, which according to me was not done. Had it been done, I would have been selected.
Yes.
But these two things need to be gone into after having scrutinized the records. But the learned tribunal will have thought these are all well. I was well aware of this before participating. Therefore, after participating, I cannot challenge. Because that's the wrong. That's the area I'm like.
So these are the only two issues.
Two issues which I'll canvass before Lordship. The other issue was there, but I don't think I can canvass because ineligibility of one person in the selection committee was known to me that I did not challenge. Therefore, I'm not really.
So what is the finding of the tribunal? Let us.
The tribunal simply says, since you have participated, you are out. That's the order of the learned tribunal. The conclusion is, therefore, the tribunal is clear in its opinion that this applicant is unsuccessful candidate, questioning the very process in which fully participated. Not, I did not question the process. I questioned, Milord, the subsequent application of discretion by the selection committee. ও সেই বাবা করেছে অর্ডারটা এখন আছে না
Yes.
But this is the point.
Yes. You filed a reply before the tribunal.
Yes, he has filed a reply. Kindly see on page 87. Lead petitioner application number 5. He got 51.661 and serial number 4.
That's the final total.
The final total. And API score, kindly see, API score so far as petitioner is concerned 25, but Dr. Ghosh 20. But in others, kindly see academic background 12.661 and 14.048. Ultimately,
আমি বেশি
no, 66.048.
একাডেমিক ব্যাকগ্রাউন্ড
No, only one thing. Academic cardboard, APS code, and interview. Everything has to be considered. If the marks is more, then candidate has to be selected.
What is the system? I have not been able to understand.
First, APS code, academic performance, interview,
Academic performance index.
index,
There is an index. Then,
Malad percentage is there.
yes.
Then Malad APS code, ratio is calculated. He has given number 25 petitioner, but the gentleman has selected, he has got that serial number 20, but he has got marks in academic background 14.
No, what
048.
his case is that while making a final assessment, due weightage has not been given to his API. That is his case.
Yeah.
Now, how the API is to weighed in the process, that we are asking you.
But that is a problem.
If we have understood correctly, that is your case, that API has not been given due weight.
academic qualification
APS code, how to be calculated?
Because he says API was higher. So how you have assessed it that ultimately the,
Method of calculation.
have you given it to them?
APS code is not only the method of selection process. Academic background, research work.
So that is what we want you to tell us. According to you, how API is to be incorporated in the performance assessment.
Yeah.
Does it have no meaning? It has any meaning? How it is to be weighed? That is the whole issue. The tribunal has not gone into this. So we are asking you.
This is the formula exercised by the PSC.
You think we can understand?
But a very technical subject.
No, but let us at least see what it is. There must be a uniform method of doing it.
Yes.
So where is that uniform method?
PSC record
Page 102, page 102, page 102 in the reply. Paragraph 4. Paragraph 4. In the reply filed before the tribunal. After that, the applicant was asked to appear in the interview and he was eligible candidate who belongs to unreserved category with other eligible candidates to judge their suitability for the
No, where is your reply to the API issue? Is there the API issue raised in the OA?
yes
12 and 13 of this. Paragraph 12 and 13. APS code.
Paragraph 13.
13. Page 104. As per UGC guideline, 400 is the minimum score to be considered eligible for post. Recommendation of the candidate was made on the performance of the interview, whether academic background, research performance based on APS score of and quality for applications, assessment of domain knowledge and teaching skills. Interview performance were assessed and marks awarded accordingly. Each section by strictly following the UGC guidelines, marks and other information as provided in the applicant.
No, where has the applicant made out a case in his OA about the API? Which paragraph he has stated about the higher API and therefore? Did not note out.
Look, that is page 41. Nine, Roman 9, 10, 11.
Test marks in API score. So where is your response to para 10?
Just give it, just one.
That is his response in paragraph 13.
10, just give it.
Yes. Yes,
No,
can
but you have not said that despite having a higher API, he can still be assessed to be lower in the recruitment process. And if so, on what methodology? That is his only grievance. He is saying, although in API, which is an essential requirement under the advertisement, one of the qualifications, I have a higher marks than the selected candidate, higher API than the selected candidates. The total summation has emerged, putting me at a lower. So what is the weightage accorded to API? That is all he wants to know. You clarify that issue. The learned senior advocate appearing for the petition.
January. 16 January.
The formula specific for I think they would have done it properly. That API score is not so important. It is one of
Item number 3.
the habit not to run out of marks. But the general assessment is to
Yes, this was taken up on the last occasion. There was a direction to come up with a supplementary along with all the records. I have already called for the records. Now yet to arrive with the records concerned. Kindly give me a few days more so that I can come up with
for complying with the earlier order. The other side of the Xmas.
No, Lordship can post it on 17. Well,
No,
Lordship
it
has
will
already
not be-
posted one of my matters on
It
17.
will not be possible. File it. It must be voluminous. We'll have to see.
13th January. 13th January. That 13th of January.
Item number 4.
Yes. Got time for filing.
Well, it mainly come to the order. Well, the order dated 5th May 2025. And the matter is taken up by the single bench pursuant to the order contained in notification number such and applicants have
Allow
filed
us
the
to read. We'll read.
Well,
We will read. We'll read just. Yes.
that my prayer in the original application was to direct the Public Service Commission West Bengal to call candidates. So 1:5 ratio. Now, before I start, I would like to indicate that Your Lordship on 4th August 2025 had an occasion to consider the same issue, but Your Lordship was pleased to dismiss that application only one ground, that is, that the list of candidates called for interview in ratio of 1:2 has been published on 10th January 2025. The interviews were conducted in between 24 January to 9 February 2025 as per submission of the Learned Counsel of the petitioners. And Your Lordship dismissed it on the ground that they did not make any representation before
Between
the
10th and 24th.
Yes. And that was the ground on the basis of which Your Lordship has
So
decided that
regarding the same process.
same process. So this is my duty to indicate, Your
What
Lordship.
is that OA number order dated?
My lord, this is way number, this is WPST number
Sorry.
161 of 2025.
WPSC number 1.
161 of 2025, Munmun Nisha and others versus Public Service
Date
Commission.
of the order, please.
4th August 2025.
So you have made a grievance at that stage.
Yes. Kindly come to page 105. And my lord, maybe I raised this grievance to various authorities. So you kindly come to the rationale which was urged by us in the representation, which is in 105. We believe that a 1:5 ratio would be more conducive to fair and competitive
What is
selection.
the date of this representation? What is the date of this
My lord,
representation?
16th January 2025, right hand side top, your lordship will find the stamp.
This was before the tribunal.
My lord, before the tribunal. This was the part of the way.
You are appearing for the commission.
But kindly see the rationale portion. We believe that 1:5 ratio would be more conducive to fair and competitive selection process for the following reasons. A larger number of candidates in the interview stage allows for a more comprehensive evaluation of the suitability for the position. It enables the selection panel to assess a wider range of skills, experience, and aptitude. 1:5 ratio ensures that all eligible candidates have a fair chance to be considered for the interview. It minimizes the possibility of any arbitrary and subjective selection decisions. By increasing the number of candidates in the interview stage, the selection panel can identify the most suitable candidates. My lord, I'm skipping this. Given that last advertisement for this post was published around 4 or 5 years ago, many eligible and deserving candidates who have been awaiting an opportunity are concerned that the reduced call ratio might limit their chances unfairly. A lower call ratio could inadvertently restrict and diversely the quality of the candidates, potentially compromising with the selection of the most suitable individuals for the role. Only one screening test can't decide the quantity of any candidate. Well, this was their representation. Lordship 106, paragraph number 2 is the prayer portion. We kindly urge your esteemed office to reconsider the revision. If possible, try to restore the previous 1:5. This was the earlier ratio followed by the Department of West Bengal Public Service Commission to increase the number of calls made for the interview. A larger pool of candidates will not only ensure better representation, but also help in selecting the most qualified and competent individual for the post. Well, thereafter on 19 January, again, one representation before the PSC was made. Here I raised another issue. Well, I hope this message should kindly come to next page. It has come to our attention that the candidates across categories were called for interview at 1:2 ratio, except for OBCB candidates who were called at a higher 1:2.6 ratio. Moreover, it seems that the actual cutoff of OBCB candidates would have surpassed the general cutoff if interviews had adhered strictly on 8 vacancies into 2 ratio. The address, this WB PSC appears to have called 4 additional OBCB candidates, effectively lowering the cutoff of that category to match the general cutoff. That raises an important concern. Why have OBCB candidates been granted extended reservation benefits during the screening process, while other reserved categories, including SC, ST, and economically weaker section, have not received similar consideration? This inconsistency has resulted in the exclusion of many deserving candidates. So, Lordship, I have pleaded 2 situations by which I have demonstrated that how a large section of the candidates were knocked out from the process by restricting the zone of consideration for calling for the purpose of interview, restricting the ratio in 1:2. Now, the secretary was apprised on this by us on 16th of January. The details were given. Then original application was filed and original application has been dealt in this fashion, my lord. I have challenged this. So my prayer was direct them to consider for the ratio, increase the ratio. My representation was on the basis of this. Now they say that since you have not come within the zone of consideration.
So what is the law? A candidate can ask the employer to raise the ratio.
My lord, I have pointed out that for last 4-5 years, there was no recruitment process for this post. Now, considering that, always the employers,
No, the point is whether you can raise this issue or not.
Lordship, I can raise
Whether
this.
trying to justify the plea is a different thing. Does it lie in the mouth of a candidate to say that you call so many persons instead of so many persons? That is the thing we are trying to
Lordship,
assert.
this can be. Lordship, Ashok Kumar Yadav says
Yes,
that. the
let us
ratio-
see. Let us see. Ashok Kumar Yadav is on a different issue.
But it says that more people, more competition.
That is there.
Transparency.
That who is to decide, that is the issue. What is the standard required? Who is to decide? The candidate appearing or the employer? Ashok Kumar Yadav, you are right. That's on a different issue.
My lord, 1985-4.
Let's see.
CC copy আছে? Copy আছে না?
Come with copies of the judgment. Not today. Not today. The judgments sought to be relied upon. Monday. Keep it on 15. Tell him he's going. In January. December. The applicant can send it also. December.
Item number 5.
Made this honorable court.
Taking this matter by my learned friend, may I tell one thing? Pursuant to my lord's direction on the last occasion, and as failed from your lordships, then my lord, with regard to non-payment of salaries to that particular my lord, the petitioner who was otherwise transferred to other post.
Oh, it is that case.
Yes, he is not joining either to his original the post or the transfer. Now, my lord, the problem that occurred with regard to the my lord, the payment of salary, because already he has been my lord, the released. Now, my lord, the after that the discussion here and my lord, what failed from your lordship, there is already an interim order. Now, my lord, the we have already my lord, written a letter through obviously through mail to join in that earlier post, that is what original post. So
He
that
has not joined the earlier post also.
no, he was not joined in the earlier post also. Because of the fact that, my lord, that before passing of the interim order, that not to take any coercive measure by this honorable court, by your lordship, already he was released from the original post. Now neither he joined here nor their transferred post. Now, my lord, salary could not be, my lord, disbursed because of this fact.
Why he has not reported to the office?
After that, my lord, yes, it was reported before your lordship on a last occasion, and it fell from your lordship that why not a communication from our end to the petitioner so that he can join without
You have sent it on 312.
without prejudice. to
No, he
anything.
was there. Mr. Majumdar was here. He said he will join. Why he is not joining?
No, he was not allowed to join.
No, that is not correct. That is
I
not
will
correct.
show the records. The
That
records
is-
speak
that
for
is not
itself.
correct.
Have you got a copy of this?
Now, yes, now, my lord, this is a letter.
He was directed to report to the office immediately. Why he has not reported?
This has not been served on me.
Yes.
Come on.
Sir. I think yesterday or day before yesterday.
না।
Served হয়েছে দেখুন through mail এ।
Through email.
তাই কম জিজ্ঞেস করো।
না, serve করিনি।
Advocate-
Find out.
এই তো, find
Must
out.
when they are
না।
giving it here, there is no point that they will not serve it.
Because the আপনার
এটা-
client কে জিজ্ঞেস
দাঁড়া,
করুন।
দাঁড়া।
Client কে জিজ্ঞেস করুন পেয়েছে কি না। তবে পাননি।
Go tell him to go and comply with that immediately. If he is interested in getting his salary, tell him to go and comply.
Well, he said that since matter is pending here, so he would not join either here nor.
Then if he doesn't want, then
Morning, they have served.
why to make an issue, sir? Well, if it is done, ask him to go and get the
Sir,
salary.
he will immediately go and join. Let no further trouble is created and
No, see, they have said, you please come, we are processing. Shall be processed and disbursed, they have said in paragraph 3.
now this has been served as it in the morning. He will now go and join.
Let him do so.
এক্ষুনি চলে যাবে।
The letter sometimes it becomes ego on both sides clashing.
That is the issue here.
Maybe. Maybe either of the three.
Now that since he is there, the order is here. I have asked my client to go immediately join. He will join today. বলে দাও জয়েন করো তারপর রিলিজ করবে এন্ট্রি মারা থাকছে তো
He should always keep in mind that he is an employee.
yes yes he is a group D employee.
Considering that fact, we had gone in.
Yes, that's
Usually we don't interfere in transfer.
but in fact the government's own decision that group D employee should not be transferred to such a place that he cannot go.
Therefore, we took it up.
Anyway, now there is a good development. Let us hope, my lord, this goodness will continue.
Hopefully.
Join করছে তবে এন্ট্রি মোডে কি twentieth January. Finally, please to record that they have already.
I have said we have taken on record the letter.
ঠিক আছে ঠিক আছে আরে কিছু দরকার নেই এখন জয়েন করবে
Item number 6.
Listen, your lordship, directed my learned friend to submit a report, my lord, because my lord, the
It is regarding that matter, that where, my lord, that it eventually appears that everything was otherwise ready with regard to the disbursement of the retirement benefits like pension and other. But, my lord, at the end of the day, it was discovered that his, my lord, service record was missing. Because retired long back after that. Now there was an order for, my lord, the preparation of a duplicate service record. Now my lord knows that sometimes we record and they, my lord, they took the time. I'm not on that, authority took the time. Now it is, my lord, almost at final stage. If your lordship kindly have a look at the report, my lord, the language of the report may not be satisfactory, but lordship kindly have a look the report at a copy. Right. Now, my lord, if your lordship kindly have a look, instead of the report at the, my lord, the annexure herein that almost finalized because leave and other thing, my lord, that was considered and, my lord, the taken note of. Now, my lord, the last annexure, if your lordship kindly have a look, last annexure of 1st December 2025, it is from Director of Agriculture West Bengal to the Joint Secretary to the Government of West Bengal for his approval. Now, subject lordship kindly have a look, furnishing of duplicate service book and related pension and leave papers in favor of the petitioner. Now, the contents is with reference to the above subject and in continuation of reference above, duplicate service book and related pension and leave papers in favor of Sri Adanath Maji, Assistant Director of Agriculture, Purulia, is hereby sent for your perusal. Actually, it should be for your approval or otherwise. Now, kindly acknowledge. Now, my lord, it was sent only on 1st December 25. Lordship, my lord, I think if your lordship kindly fix the matter, my lord, after a fortnight. In the meantime, I think, my lord, after the coveted approval, my lord, matter can be sent to the, my lord, the AG Bengal office for the purpose of the, my lord, the last steps, my lord, for the purpose of disbursement of pension and other related matters. Almost complete, except that, my lord, it is in his table. So,
Retired from 2013, my lord.
yes, copy already.
2000
Yes, 13.
The-
Item number 7.
Lordship, I am for the petitioner led by Mr. Qazi Ardan Ali.
Led by,
Mr. Qazi Ardan Ali.
yes, what do you want?
There is a direction upon the private respondent, state respondent to file a report.
We are filing the report with your lordships.
You are filing it. Give him a copy. The report being filed is taken on record.
That has been fixed, my lord. Kindly.
After the holiday.
6th January.
Yeah. April.
Item number 8.
Shamimul Bari appeared for the appellant. He is engaged in courtroom number 11. I'm paying for short pass over, my lord.
Has affidavit of service been filed? You have it in the file, just check if there is any affidavit. No service. There is no service yet.
Lordship, regarding the item number 7, the state has filed a report today. We have to file an exception within 1 week. Kindly grant us some 1 week time to file a report.
We have adjourned it. Where is the state council?
Sir, we will inform them. Kindly fix the date.
Come with him, come with him.
Okay.
Behind him, we will not change the order. There is no service yet.
Yes, Malad, that's the last time I indicated that I served, but the status is not available in the server. This status is available only in the server. Like, kindly allow me to serve once again, my lord.
When was the matter last taken up on 26?
Last Wednesday, my lord. The lordship asked me to put it on affidavit, my lord. Because
But see, you have taken the report on 27th. We don't know what is the position yesterday or today.
so yesterday also same, my lord.
Same.
Exactly same, my lord.
Okay. So, yes.
পারো 10th হ্যাঁ 10 বার আচ্ছা item number 9
I appear for WBC DCL Lordship, the electricity company. Appellant Lordship. Before the appeal, my lord, as the instruction we have received today, the order has been complied with. Lordship. We were aggrieved long before the order of 18. On instruction, my lord, I may submit that shifting of transformer, that was the issue. That has been resolved reportedly. Lordship.
So nothing survives.
Obviously, my lord, that is.
The
Kindly, my lord, add one thing that on instruction I had submitted.
yes, yes. The learned advocate, Mr.
item number 10
On behalf of the respondent,
Rosmara.
14-13 I thought this week.
On 26/11/25, when the matter was what will be first?
Item number 11
I appear for respondent numbers 1 to 6. Lordship will kindly seize my lord's order dated 22nd November, my lord. My lord, what had happened in this matter, apart from there is a delay of 265 days in preparing the appeal by the appellant, which will appear from the report of the stamp reporter. My lord, he is a non-party in the writ petition.
22nd November.
26th. And he is a non-party in the writ petition, my lord.
You are for the corporation.
I am for the corporation.
And you? What was the issue? Retail outlet selection?
No, yes, selection he has been given and he's operating the pump for 7 years, my lord. And this person has not even filed an application for leave to appeal before your lordship also. He has simply filed an appeal.
Same order. None appears.
Lordship is dismissing, my lord.
It is, brother. It is dismissed in default. Yes.
Item number 12. Thirteen.
Same order.
Item number 14. My lord, your lordships kindly consider, my lord, on.
Not today. Why?
No, I am not standing in the way, but 16th June 2022, my lord, the earlier division bench is to direct my learned friends to, my lord, give a copy and intimation since I am appearing on behalf of the WBSCTCL in the writ petition. My lord, till date, they have not supplied the copy. Although, my lord, it's a electrocuted case, disputed question of law.
There is no provision for grant of any kind of fixed compensation to persons who are electrocuted.
No, my lord, the solacium is there, but when, my lord, our report says, yes, it is our fault. But here in the instant case, my lord, upon inquiry, it has been found that there is no fault on the part of the WBSCTCL. So therefore, your lordship knows, my lord, in Power Grid Corporation's case, Supreme Court says if it is a disputed question of facts, civil suit is the remedy. And that your lordship knows, my lord. So here, my lord, where we have admitted, yes, it is our fault. Upon inquiry, it has been found. Police report is there. Then, my lord, our solacium is there, up to 5 lakhs.
Up to
5 lakhs.
5 lakhs.
Initially, it was, my lord, less. Now it has been increased to 5 lakhs. But here in the instant case, my lord, because there is no fault on the part of the WBSCTCL authorities.
as prayed by learned advocate.
My lords, fix the matter on.
It will come now after the Christmas holiday.
After, yes, yes. Grateful.
Application is there.
Item number 15.
Application is
I requested on behalf of CHC in this matter.
In the earlier case, there is an application also for this.
Yes.
Why it is not there in the file? Yes, there in the file. Respondent. CSC, my God. Yes, same order. Yes. You give your appearance.
My lord.
Yes.
Item number 16.
Contact the applicant yet. Now, I seek your adjournment to take some disciplinary instructions from the applicant. But we still establishing contact with the applicant lordship. I need at least a week. I need at least a matter for a week.
Where is, you are Mr. Amritanshu Sen Gupta. You said that you will prepare yourself. No, last day you said that you will prepare yourself.
Take him off, at least so contact the applicant.
The learned advocate.
Item number 17.
Yes, right, okay.
May it please your lordship, my lord, I am appearing for the respondent CBI, my lord. Pursuant to the direction of the coordinate bench of this honorable court, my lord, we filed the charge sheet, and the charge sheet, copy of the charge sheet was handed over to the learned advocate for the state. And my lord, now the position is that, my lord, supplementary charge sheet and supplementary charge sheet have been filed in the trial court, my lord. And my lord, second.
My lord, in this matter, Suman Shyam is appearing for the state, my lord. My lord, we file, my lord, we want to adjournment for a week, my lord.
You are for state.
My lord.
They have
Led by
prepared an
the
appeal,
10th.
my lord. Honorable single bench passed an order. Thereafter, my lord, appeal was preferred. That the appeal, my lord.
It is their appeal.
Yes, my lord. We, my lord, CBI, my lord, we filed the, my lord, charge sheet and the supplementary charge sheet before.
Give your appearance, Mr. Swain. In the second week of January. 14.
Item number 18.
My lord, I am for the appellant. My lord, your lordship would kindly peruse order dated 19th October 2023, passed by the then Chief Justice, Honorable Chief Justice. My lord, kindly see. Your lordship would kindly come to page number 20 of Can 2.
Yes, last occasion you took a time for finding out whether any interim order has been passed in the suit.
No, not yet. Not yet. That I have taken instruction.
No, no order has been passed.
No. But in fact, nothing has been filed to that effect. My lord, that prayer for any interim relief.
There
because
is
the
no
last-
prayer. You are the plaintiff there.
Yes. I have filed this, my lord, as a backdoor process, my lord, this writ petition was filed and this order has been obtained. My lord, your lordship would kindly
In
come
the
to page
suit,
number-
are you plaintiff or are you defendant?
No, plaintiff. I am the plaintiff.
And here you are for the
My lord, here I was the
respondent in the writ proceeding.
private respondent, and before your lordship, my lord, I am the appellant.
So there are two orders. One is that you will intimate the learned advocate. The next is that you will find out whether any interim order has been passed in the suit. So what is your response on these 2 points?
My lord, advocate for the petitioner, my lord, was appeared before the appellate court. On multiple occasions, he has appeared. My lord, individual order. In fact, on the last occasion as well, my lord, he was appearing. Mr. Shamul Rai, I find.
Asking to be here, how it can be considered in a sense.
Their averment says that they were trying to open. Their prayer is also in the similar line.
Now they have obtained an order
Yes.
as if there exists a shop.
Mr. Swen.
Deep, deep.
দাদা 19-12 লিখে নিচ্ছি।
Item number 19.
My appeal, my lord. Now, my lord, in this matter, my lord, legal service authority was directed, my lord, to give advocate, my lord, because the workmen, my lord, we served them, my lord. The workmen could not be served, my lord, and the workmen did not come. So, my lord, the legal service authority was directed to appoint an advocate and to represent this case, my lord. Accordingly, my lord, so Mrs. Anita Khemka was appointed and she participated in the before the writ court, my lord.
You are the appellant.
I'm the appellant, my lord. Now, my lord, thereafter filing this appeal, my lord, I went to serve Miss Khemka, my lord. She said that she will not take my lord, and I have to serve directly to the district legal service authority. That, my lord, we have done, my lord, and we have done this today, my lord, only, my lord. So, my lord, just give us some time, my lord. I think they will.
Not today, not today. Place it on record.
Not today.
Item number 20.
I am for the appellant, my lord. I am playing for not this week, my lord.
Why, sir?
I am not ready, my lord, with the matter. This is the matter.
রেখে দাও ওইখানে রেখে
One. Well, sir, my lord, it is. I am 21.
You are not appearing in this case. You are not appearing in this.
We are in the 20.
By now, he must have been proceeded against.
Well, that's right.
By now, disciplinary proceeding must have been initiated. None appears for the appellant.
Item number 21.
I'm praying for an adjournment for a week, my lord.
10-12.
Yes.
22.
All right, not today.
Twenty-three.
I beg to appear on behalf of the
Kolkata Municipal Corporation.
Well, this is the last order passed by the Honorable Service Petition.
You will,
My lords are kind enough. Up to paragraph 96. The last paragraph 5. Was justified in deciding the order of cities that appellate instead of rate. There is first we decided that we
appellants have made out an arguable case and need oversee the action realized on the basis of the implementation of annual valuations. Accordingly, we direct no course of action shall be taken with regard to the demands raised pursuant to the implementation of the annual valuation of this court for a period of 12 weeks from the date or until further orders issued by the judge. Date application of fine within 8 weeks from the date as declared there in fine within 2 weeks thereof. However, the application opposition has been used by Kolkata Corporation, which was given to us the month of May 2025. October 2025. We are also in the world. We have also not right. What I think is for scholars today, the Lordship would kindly can't be an extension or just speak by that is my first prayer. The second prayer is your Lordship allows me by the reserve which we will be doing 2 weeks after the declaration. And thereafter your Lordship takes up this week.
You have filed a cross objection,
They have filed.
already filed.
Yes, my lord. That is not appearing in today's list. That may be listed along with this appeal.
That's why we are asking you, give us the detail.
I have the number today. Today I have missed the list.
You don't have the number.
Number.
What else is required?
And my lord, the opposition so prepared is lying in my brief. I missed the brief today, my lord. I would be seeking your lordship leave to
You
file.
have not filed it yet.
No, my lord, I have affirmed it. I have served up my learned senior, but it is yet to be filed before your lordship's court.
Take down. The applicant.
Grateful mother. ডিপার্টমেন্টে যাবে বেড়ে রাখ ওই কাগজটা রেখেছো ওর মধ্যে ট্যাগ করে দেবে এই কাগজটা কাগজ থাকবে কবে আসবে ম্যাটারটা 14 আদার সাইড 14 24
My lord, I am appealing on behalf of estate, my lord.
I am appearing on behalf of appellant, my lord, on
Last
last,
for the respondent.
I am for the estate.
my lord, on last occasion, they have filed my lord affidavit in opposition. I am praying for 2 weeks to file reply to their opposition, my lord.
Time for filing.
Deeply obliged, my lord.
$25.
I appear for the appellant, my lord.
Let us see. Let him proceed.
No, this is an appeal, my lord. The appellant before he losses is the development authority. The case of allotment of land. So the development authority has allotted the land, but the process can't be completed without the state, because we have sent we have sent the recommendation to the state government, and the state government will approve. After approval of the state government, we can complete the process of allotment. But the impugned order, by the impugned order, Velocys may find the direction was only given to the development authority to complete the entire process and hand over position of the land in question to the petitioners. Because the land will be allotted on long-term lease, there has to be a premium assessed, and payment of premium is also there. But before that, the approval from the state government is required. Now the report which the state government has filed before this honorable court, as per that report, in view of a change of the land policy, the land allotment can't be made in this way. It has to be done through e-auction.
Has to be done
through e-auction.
Where is the recommendation letter of 20th June 2012?
Page 47 of the stay application manual.
What is your stand?
We are ready and willing to allot even today, but the final approval has to come from the state government, because we are under the Department of Urban Development. Unless the approval comes from the department, and we won't be able to.
And prior to this decision of 20th August 2012, 20th June, what is the date? June, perhaps June. It's not very legible. Page 47, what is the date?
June 20.
20th June 2012.
You also, this letter Does it create a right in your favor to get the land, which can be enforced through a 226 order? The Honorable Single Judge has said hand over the land. We can understand to consider and to further process and to proceed in terms of the recommendation, hand over the land.
On the same letter, there are two entities.
Two
entities which were decided to allot. Lordship is certainly, my lord, in a 226 jurisdiction to ensure that the rule of law shall prevail. There shall not be any inequality. The only exception to the equality is Article 14, which is a negative equality. The government cannot be unequal to everyone. The other entity has already received the land.
So
now, here on the same letter, two entities were decided to allot. On the premise, my lord, all
not decided, it is just a proposal.
Well, on the proposal, one proposal so far as it was acted upon on the same footing, on the same bare
See
footing,
what
my
is
lord.
required. It's not on the same footing. The two are two distinct entities. The land size is different. Their purpose would be different. The government is to take a decision. How the writ court can set because you have given to one, give to the other.
No, my lord, no. Here, my lord, also.
And that also the Honorable Single Judge has not said that because you have given to so and so you give.
No,
It
my
says because the letter has initiated, complete and hand over the possession.
No, my lord, here, lordship is only here, my lord, so far as the landed single judge is concerned, in order to only see, my lord, that whether the order is erroneous. Even if a wrong order, lordship is well aware, my lord, may not be interfered.
Yes, if interfering with the order will give rise to a unjust situation, we may not agree.
The position of the parties, particularly, my lord, so far the development authority is not changed.
We are not on that. See, we are only on a limited issue.
Yes.
This letter, does it give rise to a situation where a positive direction can be issued in a writ jurisdiction to hand over possession of the land?
But there
You
are.
have obtained that order, therefore we are asking.
May I just.
Where is the premise for passing such a positive direction in this matter? There is a proposal dependent upon decision of the government, and whatever, the land has to be handed over.
May I just, my lord,
And that is the order under appeal. We are not very sure whether such a relief you will get even in a suit. Just see the letter, what it says. This is your sheet anchor, nothing else. It says we are recommending this to you. You take appropriate steps.
No, my lord. Subsequently, my lord, may I just show you a letter that this recommendation for
And this
handing
letter
over-
is of 2012.
My lord, they kept tight. My lord,
When has the Honorable Single Judge issued the direction?
the records would bond.
When
my
did
lord.
you file the writ petition?
I have filed, my lord, the writ petition, my lord, in 2023.
Correct. No, 24.
No, my lord. It was affirmed on 2023.
All right, 23. So 11, 12 years after this
April
letter.
2023. No, my lord,
Yes.
why I my lord, did so? My lord, there has been, my lord, an affirmation on their part that we have completed the process only, and that too, my lord, we received.
See, this authority, what can it say? It has completed the process is evident from the letter itself. But their process means nothing. The process is just a recommendation. It is contingent upon the state's decision, which is apparent from a plain reading of the recommendation itself. How can it culminate into issuance of a positive direction to hand over possession?
My lord, so far as that contingency is concerned, my lord, may I only try to impress to your lordship, my lord, that contingency, my lord, at this juncture will not surface or will not boil to any issue, because here, my lord, the state government also, my lord, all along, my lord, they proceeded on the basis, my lord, that this land was ultimately handed over to me for a noble cause, my lord, for the setting up of a handicap center.
Sir, there may be a better person to give this service. We are not going to look into that. That's not beyond the scope of the order. it may be for a good cause. There may be others who may be able to do it better. We don't know what will be in the mind of the state. You are offering to do something good, that we have seen.
Here,
But that does not mean that the moment you come, it has to be given.
Here for that purpose.
Just see the order.
But
Hand
the-
over possession within 2 months. We can understand, expedite the process, take a final decision on the matter. That, of course, can be directed. But to hand over possession in a writ jurisdiction. Or we could have said that after a decision, if they are found, then hand over possession within such and such.
If your lordship takes up in
So on the basis of 2612, hand over possession.
but if your lordship takes up this on another premise, my lord, the reading of the order passed by the learned judge, which is, my lord, impugned to your lordships, my lord, here the learned judge, my lord, was on the premise as submitted by the parties that the process were completed, but it could not be, my lord, give an effect to. That is why, my lord, the learned judge has said this. If your lordship sees the other part of the coin, lordship, kindly read me, my lord.
Please read.
Upon consideration of the submissions made on behalf of the parties.
Yes.
This court is inclined to hold that since the concerned authority has recommended allotment of such and such land in favor of the petitioner way back in 2012, the authority being fifth respondent herein is directed to complete the entire process.
I have considered what they have to say, so it is my opinion, and I hold this that view that it should be done. There is no representation that it has been finalized. There is no representation that it is complete.
May I just show you a document? Kindly comes to my lord, page.
Sir, no such document is considered by the Honorable Single Judge. We are looking at the order as it is. The order simply says I have heard both the sides, and I hold that since authority has recommended allotment way back, hand over possession. Now, mere recommendation can be made the basis for giving a possession of a government land.
Well, it kindly comes to page 56. This document is a Bengali document. Lordship, kindly do not take me amiss. Well, I would.
Why should I take you amiss?
No,
I will not understand.
Yes,
You may read it as many times as you
That is what I say, my lord. I would, with my humble responsibility, I would also, my lord, translate. And other document is at page 68. That is a vernacular language. Kindly comes to their own document under the RTI Act. Well, whether the whole, that was in 2020. Kindly help, my lord, kindly have a look. Page 61. 56 and 61. I would go with 61 first.
What is this?
Kindly see, my lord.
What is it?
This is a reply with regard to, my lord, the development with regard to handover.
So, based on an RTI reply, land should be allotted to you.
May I just say this? May I just say, kindly allow me
Yes.
to read. Is a very short, my lord.
Yes.
Whether the Haldia Development Authority have sent in a reply in respect of the urban
This
development
RTI reply is issued by which organization?
by the Haldia Development Authority, the appellant. Now, may I just say this?
They
my lord?
may
Kindly,
say they have done
my lord,
whatever is
kindly,
required.
my
That
lord,
will not be binding on the state government.
No, my lord, kindly, let me just explain, my lord. Here, my lord, the government wanted certain informations from the Haldia Development Authority. It was the fault on the part of the authority to send such informations after a long interval. That is admitted. That is what I am trying to impress your lordship. That
See,
whether
all you have to show us is that the government had decided to hand it over to you, and in spite of such decision, it was not being done. You know very well the premise for issuing a positive direction. It is only when an authority fails to do what it is statutorily or otherwise required to do in accordance with law that a positive direction may issue in exercise of discretionary jurisdiction.
Very well, I will just.
The Honorable Single Judge has said that because there is a recommendation, hand over possession. Now, can such an order sustain?
Very well, my lord. I will just check on this part, and my lord, I would inform to your lordship on this aspect, but here, my lord, kindly have a look to this
We are
document.
not
once
concerned
again,
with that.
Page
They
61.
may say everything they want to say.
No,
That will not
everything.
in any way
Not-
better
my
your
lord,
situation.
Not everything. My lord, I cannot improve the record. Whatever it is, it is, it is.
Be
Here, my lord, it
without,
says-
see, first of all, when you read, I will not understand. I take it when you say that they have it, recommended it at the highest pedestal, they are at fault, they have not taken adequate steps. Can that justify the order passed by the Honorable Senator? Cannot.
my lord, there was not an.
There has to be a finality regarding the allotment and an admitted position that yes, it is to be handed over.
Maybe that document.
Only when there is an admitted position, a direction can be issued.
Maybe that document was only, my lord, recorded in isolation to other document. The other document, what I am trying to show from page 61, lordship, kindly, my lord, bear me 60 seconds. Whether the Haldia Development Authority have sent any reply to the letter of the Urban Development Department of Government of West Bengal, Vide memo number such and such. The letter number such and such issued by the Haldia Development Authority itself. Hence, sending of reply of the said letter does not arise. Whether the Haldia Development Authority have sent any reply to the Urban Development Department in reference to the letter dated 28 November 2012. Now, kindly see, the RTI reply was given in 2020. The Haldia Development say that the requirement as sought for by the Urban Development in 2012 was still under process. They were about to give a reply in 2020.
So therefore,
now, but whether the matter of allotment of plot of land as mentioned in the Board of Haldia Development Authority in its 105th meeting is in progress or not, it is in process and progress.
So
there.
So therefore, the Red Court should direct to hand over possession.
Well, maybe, but kindly forget that part. Kindly
No,
forget
that is the only issue before us. How can we forget that? That is the only issue before us. Whether that order is sustainable.
Well, if your lordship, my lord, segregate that part, my lord, to complete.
Sir, we are here to see that whether the order is sustainable.
Very well, my lord. I do not, my lord, waste
The
your
order
time, my
says.
lord. Kindly keep it in the next week. I will just check this part, my lord. There are other matters. I'll try to satisfy because there I find, my lord.
No, next week. Come on Friday. Come on Friday. Go through whatever you want to go.
I will not be here.
These matters unnecessarily are pending.
Kindly keep it on Monday. Friday I will not be here. But I will also see, my lord.
As prayed by counsel for the respondent.
Lordship is very kind.
That's not yet.
26. One sentence, my lord. I find, my lord, that there is also a report in term by the state in terms of a previous direction of a coordinate bench. My lord, we would like to use an exception. I believe it has already been ready. May that one sentence be recorded that if we like to file an exception, we should bring. Well,
We have not found any.
Yes, that is what I was also, my lord, asking my instructing advocate.
Who is appearing for the state?
State, my lord, Mr. Day.
Take the respond number. Respond number.
Respondent, my lord, because they are the main answering party, my lord.
Number. Give us the respondent.
Respond number 3, 4, 5.
3, 4, 5.
Yes.
Because they have served a report.
Which is taken. Recorded in which order?
Recorded in
12 December 2024. 10 December 2024.
I'm grateful to my friend. 10 December 2020. Wait to actually.
You already got a time, you got an opportunity to file way back in December 24.
I say,
For 1 year, you have
that
not filed
possibly
anything.
the exception is already ready. But it is not being traceable. That is what I was only seeking this much of, that if it is found, we shall file. Otherwise, we shall come back with the exception. If sorry, it has to be. It has to be. I has to be honest and fair. The fate of adjudication is something but before your lordship.
No, but why have you not filed for the last 1 year?
Yes, that is what I was trying to search for. I do not find it. That is to be very honest, my lord, because Lorships are always with us, my lord. That I know. Now, if it is required, my lord, we shall file it my lord, on the next day. If something on basically bare facts,
Just let's
not
see
on
whether there is further order regarding this.
exactly. If there is no sufficiency, my lord, then we also do not need to use an exception. It's a bare facts because I cannot improve the facts. My lord court is a court of record. Lordship will go by the facts. I can only, my lord, try to argue whether something is I can bring something in my favor or not.
All right. The matter is being adjourned.
Allowed to participate in the table may have
26.
26 I am for the appellant writ petitioner. This is that matter regularization.
We will not do anything in 5 minutes, so we can come back after this. There's no point in starting right now.
Hello.
Item number 113.
My lord, I am appearing for the appellant.
Four orders today.
My lord, on the last occasion, my lord, I had handed up the list of list of dates, my lord, as was desired by your lordships. My lord. 10 is also there. We find no merit in the appeal requiring interference with the order of the single judge. Appeal is dismissed. It is, I will correct it in there.
Item number 26.
At 26, I am for the
Yes.
but I am the appellant writ petitioner. But I'll be concise and pointed. But the issue is that in 2006, 31st of January, but the institute writes to the MHRD, being the respondent number 1, to approve 12 posts of stenographers. Thereon, my lord, thereafter, on 2nd May 2006, the MHRD writes back to the IIM, Calcutta, stating that regarding conversion of 12 posts of stenographers to 6 posts of secretarial assistant. Now, my lord, in view of that, my lord, in 2007,
September, my lord, an advertisement was published for the post of secretarial assistant. But I participate. But I have been given appointment by due process of law, my lord, after participating in this head process. And thereafter, my lord, I have been allowed to join from 18th of December 2007. But this went on for 10 years. Now, my lord, in the meantime, my lord, I write to them for pay hike. Now, since the pay hike was not granted by the authorities, but I preferred a writ application before this court, wherein, my lord, this honorable court has been pleased enough not to direct the respondents to consider my application for consideration for regularization. Number, in view of that, number, they did not allow or they did not extend my extension, and my lord, hence this writ petition. But in the course of hearing with the honorable single judge, 2 points fell for consideration. One is whether the advertisement that was published was in accordance with law, and my lord, whether my regularization, the claim for regularization, is against the sanction post or not. But on these 2 points preliminary, my lord, the writ petition got dismissed and this appeal has been preferred by the appellant. Now, my lord, if your lordship kindly takes up page 80, this is the first letter of the institute to the MHRD, where my lord, they write that there is shortage of regular appointments. And this recruitment, my lord, is approved by the finance cabinet, finance committee of the authorities. So, my lord, thereafter, my lord, if your lordship kindly takes up page 82. There is point B, my lord, agenda item number 2. Here the post of secretary assistant has been considered. Now, my lord, page 83 is the conversion. But here, on 2nd May 2006, my lord, the MHRD writes to the authorities that conversion of 12 vacant posts of stenographers to 6 posts of secretarial assistants. The due notification was there, and pursuant to this, my lord, they had advertised also, which is at page 154 is the advertisement. And my lord, more importantly, in January 2006, when they write to them, they have specifically stated to recruit 6 secretarial staff urgently, because there was dearth in that. And but since that was perennial in nature, regular appointment, regular work, but there was an urgency for recruitment. But if your lordship kindly turns to 154. Is the advertisement, my lord. Here, my lord, the secretarial assistant 6 post contractual. Now, my lord, here, relaxation has also been granted. If this relaxation would not have been there, then I had no case at all. Relaxation has been granted by the authorities. If this advertisement was not there, I had no case at all. But in view of this, I participated with the rest of the competitors and I was recruited amongst the 6. Now, my lord, page 127, my lord, is the letter by the authorities where my extension was denied. on the preliminary ground that no sanctioned secretarial assistant is there in the institute. Subclause B.
Where's your first recruitment letter after the advertisement?
Malad, it is at page 85.
Because prior to that also you were working in the institute
Yes,
itself.
since 2003, I was working through an agency. But page 85 is my letter of joining. Interview was held on 13th of December 2007.
Yes.
Now, my lord, the extension was given to me for 10 times, my lord, till 2018. My lord, in the meantime, page 99, if your lordship kindly takes, the same authority, the Union of India, MHRD, writes to them that so far as the persons working for more than 8 years, you please take steps in respect of those employees. In view of this, my lord, no steps have been taken by them.
What is this letter?
My lord, it's the Minister of Human Resource.
What does it say that has to be done?
No, my lord, I'm just placing it.
No, you said as per this letter, nothing
my lord,
was
I am
done. So
directed
what
to
does this
enclose the-
letter ask them to do? What does this letter
lord,
ask anyone to do?
But they say for the last 8 years
No,
as an
no,
employee.
that's not how to read the letter. You have to read the letter from the first word.
My lord, may I
It is
just
some application given. It has been forwarded to the director.
no, my lord, this is a letter, my lord, in page 100 is the
Please read 99 what it says.
an appeal to the highest authority in regard to the employees under the payroll of this institute.
That's an appeal. Now what does it say?
Yes, my lord. I am directed to enclose a copy of letter dated such and such.
Received from the employees.
Employees
It's just being
working-
forwarded. What
Yes.
action? It doesn't say to take
No,
any
no,
action.
no, nothing of that sort. No, no.
It said nothing was done on this, therefore we are asking.
Yes, my lord.
It does not
But
direct
page-
for anything.
Page 100, my lord, if your lordship kindly takes up the next page, my lord.
Yes.
But this is a letter, my lord, from the ministry to all the universities. May I read, my lord? Please refer to this minister's letter of even number dated such and such on the subject mentioned above, requesting to furnish compliance report in respect of Honorable Court's order dated such and such, wherein the ratio of Uma Devi's case, that is non-regularization of temporary, contractual, ad hoc, etc. employees, was ordered unless it was through a regular recruitment process advertised through newspaper advertisement or employment exchange against the sanctioned posts only. Here, my lord, I am relying on that the advertisement was made in a newspaper and pursuant to which I participated. The only, if I may say so, that the nomenclature, my lord, I'm harping on the word nomenclature, that sanction posts. Even if that is not there, I'm entitled to regularization. Now, my lord, what the Honorable single judge has done, my lord, it has categorized my employment as illegal on 2 counts. One is that I have been appointed at the age of 48 years. And the second count is that non-sanctioned posts.
What is the date of this letter? Page 100.
Well, it is May 2015.
May is not a date.
But it may be a continuation to page 99. The letter reference is here, 4/8/2015. But that would not be, because
Cannot
it is
be.
May. It is May and it is August. Stand corrected,
Undated letter. We don't know whether this letter was ever issued or not.
But that was before the Honorable Single Judge also.
That does not mean that it was issued.
Absolutely not.
All right, please proceed.
My lord. My lord, thereafter, my lord, but we write to them for pay hike. Since I was working there, my lord, the pay hike was rejected and I prefer a debt application, my lord. My lord, page 110 is the first order of this Honorable Court, dated 13th of December 2018. Wherein, my lord, the liberty was granted by this court to prefer an application for regularization. But page 111, second paragraph is the operative portion. The Honorable Court directed them to take a decision within 25th of December 2018, whereas they take a decision after 2 months. That is on 5th of March 2019, which is at page 127, my lord.
Yes.
Now, Lord, if I allowed to place the judgments, my lord. My lord, if I'm
So this was the order impugned before the single judge.
yes, my lord.
Yes.
My lord, the Honorable Single Judge proceeded with, but pertinent paragraphs are at 46 to 46 and 47 of the said judgment, dealing with non-sanctioned posts and the age. My memo should be there. Lord.
Yes.
Paragraph 46 and 47 of the impugned judgment, my lord, deals with non-sanctioned post and the age relaxation that has been granted. But so far as non-sanctioned post is concerned, I was working there for the last 10 years, whole time.
Yes.
Perennial in nature. And my lord, the nomenclature sanctioned is not there, my lord. Even if that is not there, my lord, the honorable courts have held that in absence of the nomenclature, I should be granted regularization. Now, but so far as the advertisement is concerned at paragraph 47, but I say, my lord, if the advertisement was silent on that issue of relaxation, then I had no case. Since the relaxation is in the advertisement, and in view of that, my lord, I've been granted relaxation, but that cannot be said to be illegal. Under paragraph 5 of my stay application, I have spelled out the entire procedure that takes place for such recruitment. My lord. The judgment of Uma Devi,
Yes.
on the basis of which, my lord, my prayer was turned down. Spirit of Uma Devi was to stop backdoor entries. Now, my lord, the advertisement, if it was missing or not there, or if would have been considered that I have been appointed on the basis of 2003, since I'm working there since 2003, that would have been considered as backdoor entry. And I'm hit by that judgment. But once the advertisement was there and I participated it with other competitors,
Yes.
therefore, my lord, at max it could have been said to be irregular because of the age. And I've been and in view of the paragraph 53 of the said judgment, my lord, in Uma Devi, my lord, one-time relaxation could have been granted. One-time relief. But here the work was recognized, but not the worker. And my lord, page 102.
Yes.
Paragraph 17, my lord. This is the point I was harping on. That during the said period of your engagement with IIMC, you will devote your whole time. But that recognizes that it's a perennial nature of work. And I'm covered by the Honorable Supreme Court judgment in Jago and Sripal and Nihal Singh, as well as my lord, the last judgment that your lordship had helped us with Dharam Singh.
Yes.
And my lord, your lordship kindly takes up the last judgment, Dharam Singh, paragraph 11.
Yes.
From here, furthermore, it must be clarified the reliance placed by the High Court on Uma Devi Supra to non-suit the appellant is misplaced. Unlike Uma Devi Supra, the challenge before us is not an invitation to bypass the constitutional scheme of public employment. It is a challenge to the state's arbitrary refusal to sanction posts despite the employer's own acknowledgement of need and decades of continuous reliance on the very workforce. On the other hand, Uma Devi Supra draws a distinction between illegal appointments and illegal appointments and does not endorse the propositions of precarious employment where the work itself is permanent and the state has failed for years to put its house in order. Recent decisions of the other judgments that we have relied upon, my lord. The Honorable Single Judge also dealt with Jago, my lord. The only distinction is that Uma Devi judgment was pronounced by 5 judges bench and it is Jago is a 2 judges bench. Therefore, my lord, the authority of the 5 judges bench which hold good, my lord. Paragraph 39 of the said judgment, my lord, of the impugned judgment.
Dharam Singh, you are referring to paragraph 11.
Yes, my lord. And more importantly, it would be pertinent to rely upon paragraph 8 as well, my lord. 8, 9 and 11. And 15, my lord.
8, 9, 10, 11 all.
8, 9 and 11. my lord. But if your lordship takes up Jago's judgment, my lord, page 135 of my compilation.
Yes.
Paragraph 7. 133.
Yes.
My lord. They urge the High Court to recognize their long and continuous service, the nature of their work. Page 1. Paragraph 6. They urge the High Court to recognize their long and continuous service, the nature of their work, and the lack of any backdoor or illegal entry. They highlighted that they had functioned without any break, performed tasks equivalent to a regular employees, and had been assigned duties essential to the regular upkeep, cleanliness, and maintenance of the respondent's office. The High Court, after examining the tribunal's decision and the submissions advanced, concluded that the petitioners before it were part-time workers who had not been appointed against sanctioned posts, nor had they performed a sufficient duration of full-time service to satisfy the criteria for regularization. It relied upon the principles laid down in secretaries such and such, holding that the petitioners could not claim a vested right to be absorbed or regularized without fulfilling the requisite conditions. The High Court further observed that the petitioner did not possess the minimum educational qualification ordinarily required for the regular appointments, and additionally noted that the employer had subsequently outsourced the relevant housekeeping and maintenance activities. Concluding that there was no legal basis to grant the relief sought, the High Court dismissed the writ petition. Agreed by this decision, the appellants have approached this court by way of these appeals. On behalf of the appellants, the following arguments have been advanced before us. Continuous and substantive engagement. The appellants emphasize their long, uninterrupted service spanning well over a decade and in some instances exceeding 2 decades. They argued that their services were neither sporadic nor project-based, but permanent and integral to the daily functioning of the respondents' offices. But here I was working as secretarial assistant, but which is perennial in nature. Second, my lord, nature of duties. Their responsibilities such as cleaning, dusting, gardening, and other maintenance tasks were not casual or peripheral. Instead, they were central to ensuring clean, orderly, and functional work environment, effectively aligning with roles typically associated with regular employment posts. Absence of performance issues. Throughout the tenure, the applicants were never issued any warning on adverse remarks. They highlight that their work was constantly satisfactory and there was no inaction from the respondents that their performance was not satisfactory or required improvement. Here, in this case also, I have not been targeted by any red marking in my service career. Compliance with Umadevi guidelines. The applicants assert that their appointments were not illegal, but at most irregular. Drawing on the principles laid down in Secretary State of Karnataka versus Umadevi, they submit that long-serving employees in irregular appointment who fulfill essential sanctioned functions are entitled to consideration for regularization. Discrimination in regularization. The applicants point out that individuals with fewer years of service or similar engagement have been regularized. They contend that denying them the same benefit despite long service and crucial rule consists of arbitrary and discriminatory treatment. Irrelevance of educational qualification. The applicants reject the respondents' reliance on formal educational requirements, noting that such criteria were never enforced earlier and that the nature of their work does not inherently demand formal schooling. They argue that retrospectively, imposing such qualification is unjustified given their proven capability over many years. Equity and fairness. Ultimately, the applicants submit that the High Court erred by focusing too rigidly on their internal terms of engagement and ignoring the substantive reality for their long integral service. They maintain that fairness, equity, and established judicial principles call for the regularization rather than abrupt termination. But here I am the victim. When I claim for regularization, they deny my regularization. Paragraph 10, Malad. Having given careful consideration to the submissions advanced and the material on record, we find that the applicant's long and uninterrupted service for period extending well beyond 10 years cannot be brushed aside merely by labeling their initial appointments as part-time or contractual. The essence of their employment must be considered in the light of their sustained contribution, the integral nature of their work, and the fact that no evidence suggests their entry was through any illegal or surreptitious route. Here also, I have been been given appointment on the virtue of the advertisement that was published on 19th September 2007. On mail, Lordship takes to pay paragraph 25 of the said judgment.
Paragraph
25. It is a disconcerting reality that temporary employees, particularly in the government institutions, often face multifaceted forms of exploitation. While the foundational purpose of temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. These practices manifest in several ways: misuse of temporary labels, arbitrary termination, lack of career progression, using outsourcing as a shield, denial of basic rights and benefits. And here also I have been denied the basic right of extension and regularization thereof. Paragraph 26. While the judgment in Umadevi Supra sought to curtail the practice of backdoor entries and ensure appointments adhered to constitutional principles, it is regrettable that its principles are often misinterpreted or misapplied to deny legitimate claims of long-serving employees. These judgments aim to distinguish between illegal and irregular appointments. It categorically held that the employees in irregular appointments who were engaged in duly sanctioned posts have served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subserved when institutions rely on its dicta to indiscriminately reject the claims of the employees, even in cases where the appointments are not illegal, but merely lack adherence to procedural formalities. Government departments often cite the judgment of Uma Devi Supra to argue that no vested right to regularization exists for temporary employees, overlooking the judgment's explicit acknowledgement of cases where regularization is appropriate. This selective application distorts the judgment's spirit and purpose, effectively weaponizing it against employees who have rendered indispensable service over decades. In the light of this consideration, in our opinion, it is imperative for the government departments to lead by example in providing fair and stable employment, engaging workers on a temporary basis of extended periods, especially when their roles are integral to the organization's functioning. And my role was also integral. Not only contravenes international labor standard, but also exposes the organization to legal challenges and undermines employees' morale. By ensuring fair employment practices, government institutions can reduce the burden of unnecessary litigation, promote job security, and uphold the principle of justice and fairness that they are meant to embody. These approaches align the international standards and set a positive precedent for the private sector to follow, thereby contributing to the overall betterment of the labor practices in the country. And I'm covered by this. If the advertisement would have been missing or the relaxation was not there, it was surely to be termed as illegal. And in Yal Singh also, sanction post was also clarified, my lord. And what the judgment of the Honorable Andhra Pradesh High Court, my lord, which I relied, paragraph 15 and 16, wherein, my lord, it was also clarified that the nomenclature sanction post is not mandatory.
Which judgment you are referring? Dhyan Chand.
Nihal Singh, my lord, is at One 13, 14 SSC 65 is at page 65 of my compilation.
Yes, which paragraph you wrote?
Paragraph 2, my lord, relevant paragraph would be 13, 14, my lord. For the submissions, where my lord, it was stated that sanction post does not fall from heaven, it has to be created by the state. But if Lordship kindly takes up paragraph 20 of the said judgment, my lord. Yes.
22.
20.
Yes.
But we do not see any justification for the state to take a defense that after permitting the utilization of the services of a large number of people like the appellants for decades, to say that there were no sanction posts to absorb the appellants. Sanction posts do not fall from heaven. The state has to create them by a conscious choice on the basis of some rational assessment of the needs. The question is whether this court can compel the state of Punjab to create posts and absorb appellants into services of the state on a permanent basis consistent with the constitutional bench decision of court in Uma Devi's case. The answer to this question, the residency of Uma Devi's case, is required to be examined. In that case, the court was considering the legality of the action of the state in resorting to irregular appointments without reference to the duty to comply with the proper appointment procedure contemplated by the Constitution.
Yes.
But this is the point, my lord. I'll seek leave to reply if necessary, my lord.
Yes.
Grateful.
I request your lordship first to look at the prayers, my lord, made in the writ petition. You're for the institute. I'm for the institute. Sorry, which page? Page 74, my lord. Volume 1. Petition, page 74. First, Lord, prayer, a writ of in the nature of mandamus be issued, directing the respondents, particularly respondent number 328 herein, to withdraw and or rescind and or cancel and or withdraw the letter dated 5th March 2019, and to further direct the respondents to regularize the petitioner and resume her service as secretarial assistant, specifically in the month of May 2019, as the petitioner will complete her age of 60 on that month. Then Lord B, it says writ of mandamus be issued directing concerned respondent authorities, especially respondent 328 herein, to continue petitioner service as regular employee from December 2007 and release all service benefits. So, my lord, it seems that she is seeking regularization from 2007. This writ petition was filed sometimes, my lord, in April 2019. Prayer C is also, my lord, a replica of prayer B. Yes. Now, my lord, the letter which she is seeking cancellation of is at page 120. This is dated 5th March 2019. the institute says that if there is no sanction post, this is not page 120. The Board of Governors, in compliance with the order dated 13 December 2018, passed in writ petition by the Honorable High Court at Calcutta, considered and rejected your representation under reference for reasons recorded in the minutes of 237th meeting of BOG held on 8th of February 2019, hereinafter reproduced. Restriction on the strength of regular permanent employees of the institute as laid down by the MHRD with a letter dated such and such, wherein MHRD had specifically mentioned that in respect of non-faculty posts, the norms specify a faculty non-faculty ratio of 1:1:1 for all institutions. There was no sanctioned secretarial assistant position in the institute. Pending decision on redesignation of redundant posts of stenographers, etc., BOG of the institute approved engagement of secretarial assistant on ad hoc contractual basis. The offer of engagement of secretarial assistant being ad hoc contractual in nature and also not against sanctioned vacant post, the mandate reservation policy in the matter of appointment in sanctioned post was not adhered to or followed. The engagement of Ms. Nupur Basu as secretarial assistant on ad hoc contractual basis on the terms and compensation offered was accepted without any demur or protest by her. No allegation or claim of violation of breach of terms of agreement engagement by the institute has been made by Ms. Nupur Basu during the period of contractual engagement. The institute, as a goodwill gesture, initiated a new contract for all contractual and outsourced employees with a view to enhance the pay and other statutory benefits in the context of the implementation of the 7th Pay Commission for the existing regular employees of the institute. The offer of revised compensation was issued to all contractual employees of the institute on 16th August 2018 and was made retrospective effect with effect from 1st January 2018. The offer of revised compensation being objected to by Ms. Nupur Basu, and on filing of writ petition, the offer was withdrawn without disturbing the operation of the existing contract, which ended on December 25th, 2018. The agreed period of engagement under the contract having admittedly ended, in the absence of any allegation or claim of breach of any of the agreed terms of the institute, there is no scope of further enforcing the said contract ending on December 25, 2018 by the institute. Now, my lord, two things. The regularization of 2007 from 2007 is from in 2019 by a writ petition. And Lord, she is also admitting the fact that she is going to complete her 60 years in May 2019. The same year that she is filing the writ. April she filed the writ petition. She knew that she was going to complete her 60th year on May 2019. And that is the age of superannuation. In fact, that was one of the reasons why the contract was not extended beyond that period. Before that, the contract was being extended. What was the date on which she would attain the age of superannuation? She kindly come to the prayer, May 2019. Month of May 2019. Must be the last day of the month. Last day of the month. And this the existing contract lapsed in December. 25th December 2018 was 2018.
18.
So 4 or 5 months before her attaining the age of superannuation.
What happened was, Lord, I'll just give your lordships the facts in proper perspective. 21st December, the contract was coming to an end. So, Lord, your lordships will find that just one minute. Lord, Lord, on 16th of August 2018, if your lordships kindly come to page 102. on 16th of August.
Yes, that's what we are saying. 31st December 18, 4-5 months prior to her
Yes.
attaining the age of.
But Lord, what happened was that she challenged this engagement letter by a writ petition. And Lord, before the court, because
This was under challenge.
this was under challenge. This
No,
is
perhaps something which was, some decision was taken to give her some better benefits which was under.
I tell your lordship, Lord,
We have not seen that yet.
no, I'll just show your lordship. Post 16th, Lord, she raised an objection. Kindly, Lord, come to that letter which is at page 107. That is on 20th of August.
So once she got the extension, then she raised an objection.
Objection. The objection was to the pay package. Lord, please come to. Says, with all due respect, I would like to submit that I am not happy to receive your reply. During the meeting in view, you failed to mention and disclose the fact that you were considering our salary as it were on 1st of July 2017 for further pay hike of 24%. With regard to the aforesaid new information, I have the following contention. Is there a special reasons, etc.? Then Lord, come to paragraph 2. We were given to understand in the meeting in front of every present attendee that you have fixed our pay scale for a 24% increase, and on the basis of that, we agreed to accept the letter. Since the meeting was held in August 17, 2018, it was understood beyond a reasonable doubt that all future calculations were to be made starting from the same year. If the salary hike was to be calculated from a non-obvious and different date, such essential information should have been explicit. I am hence compelled to invite your kind attention to the fact that I will be able to accept the letter if only pay scale is as promised and stated to be calculated from the date on 1st January 2018. In view of the above situation, I understand that the new revised letter is necessary to calculate the 7th pay commission arrears. Therefore, with due respect, etc. So, Lord, she wanted the 7th pay commission benefit was extended to even contractual employees just to give them, Lord, some benefit as regards pay. They were not entitled to this benefit. But when the institute gave it from a particular date, they said, no, you post-date it from 1st January 2018. And Lord, this was the bone of contention in the application, the writ petition that was filed. If your lordships now take the order, which is at page 110. This is an order dated 13th of December 2018.
Take note of the fact that the letter of 16th August has been withdrawn.
Yes, it was withdrawn, Lord, in court. Because, Lord, we didn't want any controversy. We withdrew the letter in court. Court said, because in court, she changed her stand and she said that direct them to regularize. Lord, may I just place
Yes, yes,
it will be
please.
very clear. Lord, please come to the second paragraph. A letter dated 16th August 2018. Has your lordship got that?
Yes, we have got it.
Was issued by the respondent institute to the petitioner purporting to revise the terms and conditions of the petitioner's engagement with effect from 1st January 2018. The petitioner is aggrieved by such revised terms and conditions and has approached this court challenging the said proposal dated 16th August 2018. Mr. Ahmed, learned counsel for the respondent institute, submits on instruction that since the revised terms and conditions are not acceptable to the petitioner, the respondent institute withdraws the letter of 16th August, which is under challenge in the present writ petition. Accordingly, the said impugned proposal dated 16th August stands withdrawn and cancelled. Then, Mr. Bari, learned counsel for the petitioner, further submits that since the petitioner has been serving the respondent institute for about 11 years and her performance has been impeccable, she should be considered for permanent absorption. I grant liberty to the petitioner to make a prayer for permanent absorption to the respondent number 6 in course of tomorrow. The respondent number 6 shall take a reasoned decision on such representation of the petitioner in accordance with law as early as possible, preferably by 25th December, since that is the date when the contractual tenure of the petitioner expires. The decision so taken shall be communicated to the petitioner on the day itself. So, my lord, court was aware of the fact that she was on contractual employment.
But this 16/8/2018 letter was withdrawn.
Because that the financial benefit which was extended to her, that was withdrawn.
So what was the basis of her continuance? That is what I am wondering.
There is an earlier letter by which she was continuing till 25th December. There is an earlier letter.
Of 25th December 2018?
18.
But this says, you see the first paragraph of 16/8/18.
Yes. Your engagement to the post of so and so agreed herein is on the terms and condition as under. The engagement shall commence and would be effective from 1st January 2018.
It shall commence and effective from by effect of this letter, and it says subject to your accepting the terms and conditions. So if she has not accepted the terms and conditions,
then the whole thing goes. Then extension up to 25th December should also go. This is quite reasonable, but Lord, let me put it on record that Lord, she was
continued.
Allowed to work till 25th.
So therefore, is it possible that it was a continuance in terms of the second paragraph at page 111? That is an observation of the court.
Yes, I'll take instructions on that. Lord, I'm myself not very clear.
Because see, it says, I grant liberty to make a prayer for permanent absorption. The respondent shall take a reasoned decision on such representation in accordance with law. Since that is the date when the contractual tenure of the petitioner expires.
Even if the letter is withdrawn, the contractual tenure is retained by the court.
By the court.
I'll take instructions on this. I'll take instructions on this. Your Lordship has raised a very pertinent question. But not the fact of the matter is that she was allowed.
She continued till December 18.
That she was allowed. Now, Lord, before we get into the law, Lord, if your Lordships kindly have a look at the advertisement once at page 154. What did she apply for? But around the middle, secretarial assistant, 6 post, within bracket, contractual. Has your Lordship seen that?
Yes, yes.
So the advertisement Lord clearly spelled out that it is a contractual appointment.
And this advertisement is in a newspaper.
In a newspaper. In a newspaper issued on 19 September 2007. It was hiring various persons. Some of them were, or most of them were contractual. This was contractual. Except for the first one, I think, sub-assistant engineer, project engineer, civil, 4 posts. 1 permanent post from OBC category and 3 on contractual. The first one was sanction post. So the advertisement itself gave a clear idea to the people who were going to apply that what kind of status they will have as an employee. And there was no dispute with regard to that, because when she applied, the appointment letter, kindly see the appointment letter at page 85. First paragraph categorically says that we are pleased to offer you a contractual appointment to the post of secretarial assistant under the following terms and conditions. And the paragraphs, in each paragraph, the word contractual is repeated. So, Lord, there is no question of there being any ambiguity on the recruitment. There has been no proper recruitment. An advertisement was issued. She gave her application based on which there was an interview and she was
Not only she gave her advertisement, she was already there for the last 4 years.
she was working in another department.
She was working as a secretary to some dean for the last 4 years.
Correct. And that was also contractual. So she understood what, as on the date of application, she clearly understood what was the post and what was the requirement of the
And
post.
have a look at her application.
Yes. But I don't think the application is on record. Application. What? 152. I'm sorry, I stand corrected. 150. It's dated 21st September 2007. The advertisement was on 19th of September. Secretary to Dean from December 2003 to till date, I have been appointed as IMC through Human Resources Placement and Placement Agency on contractual basis.
You are reading at which page?
Page 152. Milord. I'm sorry. But it says, I write with reference to the above advertisement. I am working with IIM Calcutta as Secretary to Dean from December 2003 to till date. I have been appointed as IMMC through Human Resources and Placement, a placement agency. On contractual basis, I shall be very happy if I can work directly under IIM. She was originally working through a placement agency. She wanted to be a direct contractual employee.
And
Then she
the
asked for
and the
relax-
advertisement just called for application, no interview or anything.
just application. It says qualification, there is a prescribed qualification.
Correct.
Which says graduate having completed secretarial from such and such should be computer literate and good in communication skills.
No, it does not specify any benchmark for assessment.
No. They just specify the
Requirement.
It just specifies the requirement.
And it so happens that the requirement is exactly in tune with her application.
It is. She had the qualification when she was working through the placement agency. Maybe she has worked in other places as well. And the placement agency, when the placement agency placed her, she had the
Very well.
And these are the facts. Now, the learned judge, may I just take your lordships to the impugned order straight away? The findings, start from paragraph.
Page, please.
Page, the impugned order, starts. If your lordship looking at the memo, page 12, it starts.
Being here for 2 years, still I don't feel comfortable with the way your files are. You have to see how the files are maintained other places. Don't believe.
But I tell you, lordship, indexing and
Yes, that's a basic thing. The entire file is required to be paginated in a running way, and every document has an internal page. Every document you refer to can immediately look. Here it is all in bits and parts. Although the rules do require indexing and everything, I've gone through it, but not for me.
At page 33, if your lordships come.
Of the judgment.
Of the judgment. Sorry, it should be internal page 22. There are two markings.
Yes.
Paragraph 33, first place. Considering the rival arguments and submissions made by the respective parties and or perusal of the record, this court finds the writ petitioner is praying for regularization of her service in the post of secretarial assistant at IMMC, though her tenure of service ended on 25th December 2018, and thereby fix scale of pay and grant all admissible service benefits along with areas as regular employee of the concerned institute forthwith from the date of joining December 2007. Before entering into the merits, lordships can skip that. Please come to paragraph 36. Here, Lord, the Uma Devi is considered. Paragraph 34. Uma Devi's judgment is considered. Then 35 is the appreciation of Uma Devi's judgment. And then, Lord, para 36, if your lordships will kindly come.
Yes.
It was further held that the wide powers under Article 226 of the Constitution are not intended to be used for a purpose certain to defeat the concept of social justice and equal opportunity for all, subject to affirmative action in the matter of public employment as recognized by our Constitution. It is time that the courts desist from issuing orders preventing regular selection. This is all not taken from Uma Devi, is rather quoting from Uma Devi. Then Lord, please come to para 37. Appointments made without following due process or rules for appointment did not confer any right on the appointee, and that the court cannot direct their absorption or regularization or re-engagement or making them permanent. However, finally, the Honorable Supreme Court also held that the cases where irregular appointments, not illegal appointment, as explained in SB so and so, RL and Najudappa, etc., of duly qualified persons in duly sanctioned vacant posts might have been made, and the employees have continued to work for 10 years or more, but without intervention of the orders of court or tribunals.
Perhaps para 53 of that judgment.
Para 53. So I skip that. Please come to paragraph 41. 39, Lord, Jago is considered. Paragraph 39. I'll deal with Jago, Lord, separately. But this is taken note of. 39 and 40, Lord, those paragraph 26 is stated. Then, Lord, please come to paragraph 42. Or rather 41. Upon careful perusal of the aforesaid judgments, it is clear and explicit that temporary, casual or contractual employees of irregular appointment who were engaged in duly sanctioned posts and had served continuously for a decade should be considered for regularization. Lord, I just pause here for a moment. My learned friend, Lord, tried to develop his case that this is an irregular appointment. Lord, the first principle of an irregular appointment is there is a sanctioned post, but the appointment is not regular. That is what is explained in Uma Devi and also, my lord, the subsequent judgment. Your lordships will find it. There is a sanctioned post. A man is recruited, but not on regular recruitment process. And he has been discharging the duties. Now, this is taken note of in 41. Then, Lord, please take paragraph 42. May I just place 41 once. Upon careful perusal of the aforesaid judgment, it is clear and explicit that temporary, casual or contractual employees of irregular appointment who are engaged in duly sanctioned posts and had served continuously for a decade should be considered for regularization. In the present case, it is admitted fact that the writ petitioner was initially appointed as Secretariat Assistant on a contractual basis for a period of 2 years from the date of her joining. The said appointment would be extended further based on satisfaction of her performance and as per requirement of the institution. Emolument was fixed at consolidated salary per month. Petitioner joined in the service on 26 December and has served as secretarial assistant for more than a decade without any break and adverse remark. However, her appointment was purely temporary basis and was extended from time to time. She has drawn lastly a consolidated emoluments of 36,500 without any terminal benefits like gratuity, provident fund, encashment, etc. Then Lord paragraph, please come to paragraph 51 straight away. This court is of the considered view that such appointment was clearly in violation of the notification of recruitment. The writ petitioner was well aware about the consequences as her appointment was purely on a contractual basis, and the same was time to time extended without any demur or objection or any claim. She had filed a writ petition challenging the appointment letter dated 16th August 2018. Thereby, she was engaged with effect from January 1, 2018 up to December 31, 2018. And while disposing of the said writ petition, the coordinate bench has given liberty to apply for regularization of her service, which was turned down on the ground that she is not eligible for regularization as the post was not against the sanctioned post. This court does not find any substantive evidence that the post was sanctioned by the concerned authority. It was only an arrangement in place of stenographers as per request and proposal of IMMC. None of the judgments relied upon by the petitioner are applicable to the present case. Rather, the Honorable Supreme Court in Uma Devi's case, then Lord paragraph 43 is quoted. Equality in public employment. That paragraph is quoted. Then Lord paragraph 53. This is also Lord quoted from that Amarkant Rai, State of Bihar. And then paragraph 54. Consequently, this court does not find any illegality in the rejection of a representation dated 14 December 2018, as her engagement had ended on 25th December 2018, and no further extension was granted by IMMC. Moreover, her appointment was apparently illegal and not made against sanctioned post. Therefore, the order rejecting her prayer warrants no interference. Accordingly, the judgments referred by the learned counsel for the petitioner, most of them are based primarily on the principle laid down in Uma Devi's case, are no manner of application, as the appointment was neither made in accordance with recruitment rules nor against the sanctioned post. But this is the foundation of the finding of the learned judge, that Lord, the appointment was not made according to recruitment rules. Neither these appointments are against the sanction. The appointment is against the sanction.
So in Jagwa and Dharam Singh, how the initial recruitment was made?
Now, Lord Dharam Singh, I deal with Dharam Singh first. Lord, kindly take that Dharam Singh's judgment. But what is important here is paragraph 4.2. If your lordship kindly come to first. On 24th October 1991, has your lordship got that?
Yes.
The commission resolved to create 14 posts in class 3 and class 4, sought sanction from the state government. On 27 December 1997, the state sought particulars of daily wage hands and their service details. On 11th February 98, the commission furnished a list of 14 daily wages, which included the present appellants. On 16th October 1999, the commission reiterated its request seeking sanction of 2 posts of driver and 10 posts of peon, mali, chowkidar, adverted to administrative exigencies and referred to earlier correspondence. By letter dated 11/11/1999, the state rejected the proposal citing financial constraint. Now, your lordships may kindly come to paragraph 7. Having kindly take the second sentence, I think that will suffice. The original writ petition, has your lordship found that?
Yes.
before the High Court expressly assailed the state's refusal dated 11/11/99 to sanction post for the commission and sought a mandamus for creation of post with consequential consideration for the appellate.
Yes, where the High Court directed to send a fresh recommendation.
Now, Lord, what happened is the Supreme Court was considering a situation where a recruiting body wants the post to be sanctioned, but the government was not sanctioning. And Lord, the recruiting body is considering that these are persons who are regularly required by the recruiting body, but the government is not sanctioning. That was the issue, Lord, in Dharam Singh. So it was the recruiting body or requiring body, they were saying that this is a perennial requirement, I need a sanctioned post. So Supreme Court felt that this was an unfair labor practice, where the employer, he feels that these posts are required to be sanctioned, but the government is refusing. Kindly come to paragraph 11 now. Furthermore, it must be clarified that reliance placed by the High Court on Uma Devi to non-suit the appellants is misplaced. Unlike Uma Devi, this is the distinguishing feature, the challenge before us is not an invitation to bypass the constitutional scheme of public employment. It is a challenge to the state's arbitrary refusal to sanction posts despite the employer's own acknowledgement of need and decades of continuous reliance, etc. So, this was on a different context altogether. The Supreme Court was considering a different situation. And this is how the Uma Devi is distinguished, saying that this case has no resemblance with Uma Devi. That is what paragraph 11 is.
Therefore, it was said that it cannot be used as a shield.
Therefore, this is squarely distinguishable on facts.
And Jago?
Now, Jago. Jago is at page 135. But in Jago, if your lordships will kindly take the factual aspect first. Paragraph 4. The appellants before this court, being appellants so and so, were originally engaged by Central Water Commission on part-time ad hoc terms. Appellant number 1 was appointed as a Safaiwala, etc. All three were primarily responsible for cleaning and maintaining the office premises under CWC. Applicant number 5 appointed in 2004 as Khalashi. They were all category 4 employees. Throughout their engagement, these individuals performed essential housekeeping and support functions at CWC in establishment, including its offices at Faridabad, ensuring daily upkeep, contributing the smooth functioning of the commission administration operation. The Supreme Court was considering that whether there was an employer-employee relationship. The lordships will find that there is a further discussion on this. Kindly come to paragraph 10. Having given careful consideration to the submission advance and the material on record, we find that the appellant's long and uninterrupted service for periods extending well beyond 10 years cannot be brushed aside merely by labeling their initial appointment as part-time contractual. The essence of their employment must be considered in the light of their sustained contribution, the integral nature of their work, and the fact that no evidence suggests their entry was through an illegal or surreptitious nature. Then the court, Lord, ultimately considers Uma Devi and para 20. It is well established that decision in Uma Devi does not intend to penalize employees who have rendered long years of service fulfilling ongoing and necessary functions of the state's instrumentalities. The said judgment sought to prevent backdoor entries and illegal appointment that circumvent constitutional requirements. However, where appointments were not illegal but possibly irregular, and where employees had served continuously against the backdrop of sanctioned function for a considerable period, the need for a fair and humble resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis can, over the time, transform what was initially ad hoc or temporary into scenario demanding fair regularization. Now, my Lord, court also takes note of that continuously in the backdrop of sanctioned functions. Sanction actually, my Lord, I'll show from Uma Devi, this sanction functions is actually, my Lord, sanction post. Uma Devi says sanction post. Then, Lord, paragraph 6 and 7 of the judgment is quoted. Kindly, Lord, see paragraph 25 and then, Lord, 26. It is a disconcerting reality that temporary employees, particularly in government institutions, often face multifaceted forms of exploitation. While the foundational purpose of temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. These practices manifest in several ways. Then misuse, arbitrary termination, etc. While the judgment in Uma Devi sought to curtail the practice of backdoor entries and ensure appointments adhere to constitutional principles, it is regrettable that its principles are often misinterpreted or misapplied to deny legitimate claims of long service employees. This judgment aimed to distinguish between illegal and irregular appointment. It categorically held that employees in irregular appointments who were engaged in duly sanctioned posts and had served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claims of the employees, even in cases where their appointments are not illegal but merely lack adherence to the procedural formalities. Government departments often cite judgments of Uma Devi to argue no vested right to regularize temporary employees, overlooking the judgment's explicit acknowledgement of cases where regularization is appropriate. This selective application distorted the judgment spirit, etc. In the light of this consideration, in our opinion, it is imperative for government departments to lead by example in providing fair and stable employment. Engaging workers on a temporary basis for extended periods, especially when their roles are integral to the organizational function, not only contravenes international labor standard but also exposes the organization to legal challenges and undermines employee morale. By ensuring fair employment practices, government institutions can reduce the burden of unnecessary litigation, promote job security, and uphold the principles of justice. This approach aligns with the international standard, sets a positive precedent for the private sector to so and so. In view of the above, then Lord, the relief. There are two things, Lord, I want to say on this. Lord, this judgment does not make a distinction of Uma Devi. On factual score, this judgment finds that, Lord, the expression is kindly give me one.
In the case of Jago, were they appointed initially on ad hoc basis against regular vacancies?
Lord, that is not very apparent, Lord, from the facts, because except for paragraph 4, they were appointed at Safaiwala, and Lord, one was appointed as a Khalasi.
Para 5. See para 5.
Para 5. part-time contractual.
No, it goes on to deal with the nature of vacancy.
Now, there are two aspects of the matter. I just wanted to make a submission on that.
Because it was the stand before the tribunal that they were not engaged on what is considered regular vacancies. This was a plea there also.
Correct. But Lord, the learned judge, Lord, the Supreme Court considered that, Lord, they are engaged in a perennial situation where, Lord, they are running the institution. The Safai Walas are cleaning, the other staff, Lord.
Even if not against sanction.
Even if not against sanction post, but Lord,
to that extent, how we reconcile with the
well, Uma Devi, you don't, Lordship need not reconcile because Lord, Uma Devi is a constitution bench judge. And Lord, vis-a-vis this, your Lordships may kindly consider Uma Devi once.
53, it clearly says against sanction post. 10 years without an aid of the court's order.
But,
against the sanction post, duly qualified and initial recruitment through a process recognized by law.
Yes. Lord, kindly, would your Lordship kindly take Uma Devi's judgment once? Please come to paragraph 45. While directing the appointments temporary or casual, be regularized or made permanent, the courts are swayed by the fact that the person concerned has worked for some time. That is correct. So, this consideration, Lord, same consideration, fell before Lord the Constitution bench. And Constitution bench takes a view that even if that is so, then also the constitutional scheme can't be defeated in this process. Now, Lord, the same situation here in Jago. The Supreme Court, Lord, after all, Lord, sitting in Article 142, 141.
That is why we wanted you. Is it? Does it appear from anywhere?
Lord, on the body of the judgment, it does not. But Lord, this is a constitution bench judgment which has considered the same situation. And that's why, Lord, I placed paragraph 45.
Which is
Which is Lord, may I also request your Lordship to kindly take paragraph 12 of Uma Devi. In spite of this scheme, there may be occasions when the sovereign state or its instrumentalities will have to employ persons in posts which are temporary on daily wages or additional hands, taking them in without following the required procedure to discharge the duties in respect of the post that are sanctioned and that are required to be filled in terms of relevant procedure established by the Constitution or for work in temporary posts or projects that are not needed permanently. This right of the union or of the state government cannot but be recognized, and there is nothing in the Constitution which prohibits such engaging of persons temporarily on daily wages to meet the needs of the situation. But the fact that such engagement are resorted to cannot be used to defeat the very scheme of public employment. Nor can a court say that the union or the state government do not have the right to engage persons in various capacities for duration or until the work in a particular project is complete. Once this right of the government is recognized and the mandate of the Constitution requirement for public employment is respected, there cannot be much difficulty in coming to the conclusion that it is ordinarily not proper for the courts, where acting under Article 226 of the Constitution or under Article 32 of the Constitution, to direct absorption in permanent employment of those who have been engaged without following a due process of selection as envisaged by the Constitution. So, my lord, both these paragraphs deals with a similar situation which the Jago had dealt. It's not an exceptional situation that Jago was dealing. But, my lord, the judges, honorable judges felt, my lord, that they were menial staff who are working in a class 4 post or whatever. But, my lord, what I want to distinguish here is that here is a person who is intellectually accomplished, who's applying, Lord, he's not applying for a class 4 post, who's applying, Lord, for a post on contractual basis. She was earlier working through a placement agency. Now she wanted to do the contractual work directly under the institute. So, Lord, there is no question of any misconception. Here was in Jago was a case where, Lord, these employees were engaged without a sanction post, and Lord, they were being, the Supreme Court perhaps felt that they were being exploited for cleaning operations and day-to-day institution. They're running the institution. They were actually helping the institute to run the institute. Lord, there are line of cases where, Lord, employer-employee relationship, for example, the canteen matters, the Reserve Bank canteen, whether that is part of the establishment was being considered, where the Supreme Court in one case held that canteen was part of the establishment because it was serving food, etc. Those employees were the employees of the establishment. So, Lord, there are cases and cases. Here, Lord, the Supreme Court felt that apart from them, there are no sanction posts. So, these are requirements which was being continued. But, Lord, here is a case where, Lord, intellectually, one can't say that she doesn't understand the implication when she applies for contractual job. And she has continued, accepted, Lord, year after year, the renewal of the contract. 2 years and then renewal. In fact, and that was one of the reasons why I indicated, Lord, in 2019, when she wanted regularization from 2007, the earlier period she had no grievance. Even in 2018, she had no grievance except for some differential payment which she wanted from a particular date on January. Similar, a cause of action with which she came, she didn't want that, she abandoned that, and she said that let them consider my case for absorption. The court, Lord, without considering any other thing, considered the prayer and said, very well, you make a representation, they will consider. This is how, Lord, the situation arose. And the other thing, Lord, which I wanted to point out to your Lordship is that here it is not the case in the writ petition that there was any inaction or on our part to approach the government for sanctioning of the post, as in the case of the other judgment. That is not under challenge. That is not under challenge. They are not contending that, Lord, that there was we had approached the government or the government has refused, or we have not approached the government. These case has not been made out at all. The last judgment which was cited by my learned friend, that was on the basis of the employer asking for certain sanctions, sanction posts, government is not giving. And that is the challenge. That is the challenge here is nothing of that sort.
Dharam Singh, what happened is in and around the time they were engaged, simultaneously the proposal moved.
Correct.
So the intention has been gathered from that matter.
Yes. And the Supreme Court says that the employer has assessed its requirement. Employer says, I need sanction.
Declaration regarding its perennial is not required. The employer itself was
correct
of the view that it is a perennial.
Absolutely.
So it moved for sanction.
Absolutely. And Lord, the other aspect of the matter is that insofar as the rules of the institute is concerned, Lord, institute has no power to create posts. We need not go into that issue now because obviously that issue has not been raised.
No, but you have converted it with concurrence of the MHRD.
That is, Lord, Lord, have a look at that document once. We wanted that. That was not allowed.
Yes.
That was not allowed. That was not allowed. Kindly, Lord, have a look at that. I think that is 2006.
Yes, thereafter you advertise.
I
Is that letter? We saw it, I think, somewhere.
That is at page 85. It starts at page 80. Your lordships will find. But first is the letter of 31st January 2006. Has your lordship got that?
Yes.
But where they say that there were 12 posts of stenographers and there is a proposal to engage, proposal to appoint. Kindly see, Lord, page 81, just above B. It says contractual engagement will be done through the due process of selection, interview, etc. Has your lordship found that?
Therefore, we asked you, is there any assessment under the advertisement?
This assessment was there. I'm sorry. I should have pointed it out. This was there. Kindly, Lord, see the last paragraph also.
Yes.
And the reply of the government is at page.
The board said process of selection, interview. Does the advertisement contemplate interview?
Yes. And Lord, the reply of the government of India was at page 83. Government said that the post that you're talking of is deemed abolished because it remained vacant. And
Yes, lapse after a year.
Yeah.
That we have seen in last day news.
And he says that as regards the proposal, other proposal, says that the relevant rules indicating educational qualification, duties, etc. may be furnished to the ministry urgently for further processing of the case. So, Lord, from the ministry itself, Lord, when the proposal went and the proposal came back, it was conceived of a contractual employment. And this is also, Lord, the distinguishing feature for Jago. This is also, Lord, in my humble submission, the distinguishing feature for Jago. Because here, Lord, when the recruitment was made, the basis of the recruitment was not very clear. Here, Lord, the basis of recruitment was crystal clear, both to the employer as well as to the central government, which also runs the institute. And in fact, my learned friend has also shown your lordships the letter of the central government at page 100, which is not a prior letter, May 2015. Undated, yes.
Could anyone find the date of this letter?
But this is, I don't think, Lord, there was.
Refer to in that 80, page 80.
Kindly give me 1 minute, Lord. Page 80 টা দেখো তো। Page 80 টা দেখ। Of December 2015. No.
Is it 2015 or 5?
2005.
Page 100 is perhaps 2005.
May 2015.
No, it cannot be.
15.
It
50.
cannot be. It is 15 because in the body it talks
Correct. It's 2015. No, my lord, page 80, my lord, does
not refer to this. So whether it is prior to that, we don't know.
Lord, this is shows May 2015 and page 80
January
2006. Much prior. Lord, this is an instruction given to all, Lord, institute, all heads of the institute, that you do not recruit anybody except for regular recruitment process. Your lordships will find that. Kindly come to the second paragraph. When you are engaging somebody against the sanction post, it should be through a regular recruitment process. This is a direction given to all institute by the central government. This is really, Lord, saying that don't violate Umadesh. This is not really restricted to any particular. They are just saying.
This is perhaps pursuant to some direction passed in the writ proceeding.
Yes, that is the subject, Lord, shows.
Maybe by the apex court, because it says the writ petition civil number so and so.
Yes,
that is the way it is registered there.
Must be, Lord, pursuant to some directions given by the Supreme Court, but this is a general instruction that do not fill up the sanction post unless it is by a regular recruitment process. And this was not, Lord, a regular recruitment process. These are my humble submissions. And Lord, I say that the learned judge, Lord, has taken the pain of going through the judgments. He has considered, Lord, everything. This judgment, Lord, does not require any interference by the judge.
May I just reply to it? Page 80, my lord. Your lordship, kindly takes up page 80. Though, my lord, my senior has elaborately stated it, but the secretarial assistants, but keeping Dharam Singh into consideration, the secretarial assistant, my lord, due to retirement of employees and no regular recruitment against such positions, there is a tremendous dearth of secretarial staffs. So the requirement was of them. Thereafter, my lord, your lordship has just put a question that whether this, what is the process of this recruitment? My lord, page 81, the contractual engagement would be done through the process of due selection interview. Now, my lord, we have spelled out in details paragraph 5 of our state application. What is the process all about and what it contains? But if your lordship kindly takes up paragraph 5 of our application.
That was before we learned a single judge.
Yes, we have spelled out everything before that also and before this court also. We have not suppressed or overpowered anything.
No, what you are filing in a state petition here.
My lord.
Was that material before the single judge?
Yes, everything was before the single judge, my lord. Nothing we are overpowering it. Yes. And my lord, the last line, my lord.
Of which page you are showing?
My lord, page 81.
No, You just now you said from the state petition.
State petition, my lord, paragraph 5, page 7. Yeah, read, my lord.
There is no procedure. You are not
No, no.
left with any
The
procedure.
due process that this process is saying, my lord, at page 81, the due process of selection and interview. The due process consists of, my lord, shortlisting, skill test, computer test, followed by personal interview.
Where is this abhorrent in your red petition? Where is this abhorrent in your red petition? Please show.
My lord. Paragraph 5. Lord, page 47, my lord. Yeah. Starts with page 46, my lord. I stand corrected, my lord. Paragraph 5. The petitioner states that the issuance of the appointment letter dated such and such, the said institution offered contractual appointment to state secretary post upon following due process and the rules of recruitment of the central government. That as per the letter of appointment, the appointment was contractually for a period of 2 years subject.
There's nothing. Just saying due process does not make it.
And the last
cannot
point.
improve upon that at every stage.
No, my lord.
Therefore, we asked you, whatever you are saying, was it before this?
Well, I'm just coming, my lord.
It was not there. The advertisement itself does not talk of anything. It's negotiable. Just see in the bracket, it says negotiable.
No, no, I'm coming to that, my lord. Satisfying me.
This way, the institute has employed all of you. That also after Uma Devi's case. The board says to do it by a process in accordance with law after an interview and anything. And it is a very shocking coincidence that you make an application, you say that if a relaxation is given, I will be accommodated, and everything is there in the advertisement. You enter. But what is the procedure? Who else qualified? Who else participated? Nothing.
But
where is the result of the recruitment process?
6 candidates.
Where is the result?
But it is up to them to disclose
No,
it.
it is up to you. You are the beneficiary of that process.
I am
You
aggrieved
have
by
to
such a
show.
process.
You are not aggrieved. You are beneficiary. You have derived benefit
So, my lord, I'll
for
come to that.
11 years from that process.
Yes, my lord, if
For
your
you
lordship
to
kindly,
say that it was legitimate.
my lord, if your lordship kindly takes up
They
page.
can't be called upon to say regarding your appointment.
But so far as sanction post is concerned, my lord, if your lordship kindly takes up page 82.
Sanction post, you know it is not a sanction post. You have said.
But I'm coming to that. I'm satisfied to that, my lord.
Yes.
But the agenda item number 2.
Where it is your stand that your appointment was against the sanction post.
Yes, it is against the sanction post.
Show from the writ petition.
But I'm showing the annexure.
Please show where you have said that your appointment was on a sanction post.
But it is the interpretation.
There is no such thing as interpretation. Either there is a post or there is no post.
Yes, my lord. The honorable courts have held that nomenclature is
That
not
is a
mandatory.
different thing. That is a different thing. But it's not your case that your appointment was on a sanction. You may say that continuance over long period may result in a conclusion that yes, it is as good as a sanction. But it's not your case that it was against a sanction.
But I'll satisfy your lordship question.
That you have already said. Don't argue again.
My lord.
You have already said,
my lord,
that since we have continued, it is a perennial nature, relying on Dharam Singh and Jago, that it should be treated as a sanction.
Yes, my lord.
That you have said,
I'll
but
just-
you have never said that it was against the sanction.
My lord.
They are completely two different things. You want to say anything in response to his citation of the judgment, then say it. Otherwise, factually, you have said it.
But factually, there is nothing to improve on it. But we have said it. Page 82 says that they have sanctioned.
Repeat the facts.
My lord.
Reply is not for repeating the
My
facts.
lord.
Reply is
Only for law
anything
points.
that he has-
Yes,
You want
certainly.
to repeat anything, you can say so.
No, my lord. I will not improve anything on the facts. But the judgments that have relied, that's grateful, my lord.
recorded the submission so that